Well, good morning to everyone. It's 9 o'clock. This is the August 15th meeting of the Oil Conservation Commission. I'm Gerasimos Rosados. I am the acting director for the Oil Conservation Division in the interim, so nice to meet all of you. And it is time to call our meeting in session. So we'd like to do a roll call. As I said, I'm Gerasimos Rosados. I go by Jerry. I'm the acting director, and I'm Oil Conservation Commission chair. Doctor.
I am Dr. William Ampoma, designee of the Energy Secretary.
And I believe Mr. Bloom was going to be joining us electronically today. Mr. Bloom, Commissioner Bloom, are you on? There he is.
Could we have Commissioner Bloom just test his mic so we can make sure we hear him? Is he muted?
Well, I think we lost him again. No, Commissioner Bloom?
Hi there.
Awesome.
Good morning, everyone.
Okay, so I believe we have a quorum. So let the record note that we do have a quorum. Okay, we have this week's agenda. Everybody have a copy of the agenda and it has been published. Is there any changes that we need to do or any edits or anything like that? Is this echoing because it's too far away from me, Sheila?
It could be if you are logged into the meeting on another device, mute the volume on that device.
I have.
Okay, let me try to turn down the volume then on your mic. Okay, let's see if that's any better.
Okay, yep, there we go. So were there any changes or anything?
No, not from me.
Awesome. Do we have a motion to accept the agenda?
I so move.
I second.
Excellent. So our agenda has been accepted. Thank you. Our next motion is our meeting minutes from last meeting. Any changes that we need to do to the meeting minutes?
I thought the meeting minutes looked good. I would move to approve.
Excellent.
I second.
Okay, so we'll move that our meeting minutes are accepted. Thank you for that. All righty. So now we have our cases. We're coming up to our cases. Our first case this morning,
Mr.
and of
Chair?
course, yes, please.
I'm sorry, do we need a vote on the agenda and the meeting minutes from the last month? Or do you just want
I
to say
think
that
we
they
do.
Yeah, that we have that I think you could say they passed unanimously.
Mr. Chairman, members of the commission, yes, that is correct. We should formally have a motion.
Sorry, let's formally have a motion then.
And
I motion that we accept the meeting minutes and the agenda.
I so move.
And
I second.
excellent. So both of them are accepted, correct? Or
Let's
we
have
have to do it separately?
we do need a roll call vote because we have one member that is appearing virtually.
Okay. So Commissioner Bloom.
Approve.
Okay. Commissioner Ampoma.
Approved.
And I approve as well. Excellent. So now they're accepted?
Yes, the agenda and the minutes have been accepted by one motion.
Excellent. I'm getting my feet wet, people. I'm sorry. I'm learning.
And I'd like to thank Commissioner Bloom for reminding me how the Open Meetings Act
Yes.
works.
Thank you, Commissioner Bloom.
Apologize.
I need all the
No worries.
reminders I can get. So plus it's blazing hot in here. So I apologize. I look like I'm sweating, but it's like heat is right here. So stress and heat. Gotta love it. Right? Okay, cool. Now we can get to our next part, which is our actual procedures. Our first case today is the consolidated cases 24018 through 19 and 24024 through 24027. An application by Empire for New Mexico to revoke the injection authority for the Andrade Dawson SWD number 001 in Lee County, New Mexico. Are all parties present? Excellent. Go ahead.
Mr. Chair, members of the commission, if I may brief the commission on my review of the the expedited motion and the response and the reply.
Please.
As you may have gleaned from them, the issues raised here do tend to relate to the pending hearing that is set in a few months before Hearing Officer Rip Harwood, and relate to the propriety of the respondent in this motion's continuing injection of produced water into those basins at issue. Certainly, a lot of the issues raised in the expedited motion do relate to what would be hopefully resolved at that hearing. In other words, the propriety of and whether there is any, there are obviously legal issues as well. There is an issue raised in the expedited motion, however, that needs to be addressed today, and that is the accusation, for lack of a better word, in the expedited motion that the respondent has been exceeding its permitted amount of injection of produced water. And that, of course, is of serious concern to the commission. Any violation of its of permits warrants immediate consideration. So the expedited nature of this motion is certainly warranted in my view. And interestingly, there was no evidence submitted with the expedited motion asserting these over injections. Nonetheless, the response didn't dispute that. It rather elliptically referred to, it rather instead argued that as part of framing it as part of the standards for preliminary injunction, well, whatever damages are marginally are being caused to Empire by whatever over diversion amount there is would not weigh in favor of granting this as a preliminary injunction. I am not sure I agree with that argument. There's an analogy to that preliminary injunction, Rule 66, of course, but it does seem to be a concern that it's basically, even though there's no evidence and we don't know what the amounts are, that there is apparently an over diversion under that permit. So what I would recommend, because we don't know the amount, we also don't know the effects that would be resolved at the upcoming hearing through testimony and argument and a hearing officer's report. Nonetheless, we do need to deal with this. My recommendation is for the commission to immediately order, and this would be an order effective immediately, for the respondent here to immediately cease any over diversions, not over diversions, sorry, that's a state engineer term, any over injections that they are currently they may be perpetrating. That would be going to immediate effect, to provide a full accounting of any such over diversions to the hearing officer and to all other parties in the case as part of that hearing, so the commission can then assess that as part of the rest of the issues in that case, and to basically hold in abeyance any further action on the expedited motion. So, of course, that's one way to handle it that perhaps, splits the baby, so to speak, without having to take the drastic step of shutting anyone down. But nonetheless, I think would help get to the bottom of this and certainly and stop any violation of any permits at the time. So if any of the commissioners have any questions for me or of the parties, and certainly if the commission wishes, they can hear argument of counsel on this point, but it does seem like a fairly straightforward motion.
Mr. Rubin, Mr. Chair, if I may.
Please.
I'm wondering, I guess a question related to scope and jurisdiction here. And I would like to hear from the parties, and particularly the OCD. I'm wondering if this matter should be first addressed by the OCD and handled as a typical, I guess to say typical for lack of a better word, accusation of over-injection.
Mr. Moender, or you're representing the OCD, correct?
I am, Mr. Chair. Commissioner Bloom, just to make sure I'm clear on what the request is, it sounds like you want to know what OCD's overall position is on the allegation of over-injection, or are you talking about within the confines of the relevance to this particular matter?
maybe both, but I'm wondering if now that you mention it, but I'm wondering if this might be something that the OCD would typically deal with and perhaps should deal with in this case, given that this claim of over-injection has been made. I'm thinking that the first stop would typically be the OCD and not the OCC.
So as to, and generally speaking, an allegation between operators like this is one that we would certainly take a look at. We do have some caution when the matter's actively being litigated. And we don't know yet what the evidence will show in this case. And I think there's some value. And that's really the nature of my response was written towards that, Commissioner Bloom, is that we want to see all the evidence. We want the opportunity to examine witnesses, and whatever flows from the hearing would be most likely material to our jurisdiction and our role. And then at that point, we would reevaluate and then look to pursue whatever remedy that may be appropriate at that time. It's not often the case where we have a matter that OCD appears in where we'll get this pointed of an accusation. So I think that the interests of the public are going to be served by fleshing out the evidence in the hearing, see what comes out, and then evaluate matters from there.
Chris, I have a follow-up on that one. So is it a position of OCD that they do not have the injection volumes and they do not have the injection pressures to see straight away whether the accusation is true or not?
At this point, I would not be able to tell you what that specific evidence would look like. I would imagine we may have some filings that would reflect a yes or a no on that. And that's why OCD wants to proceed pretty severely with this hearing, is to suss all this out. And the other angle on this is there's an opportunity to get testimony about these things, additional information that we could get potentially from an RFI, but there's also the issue of we can get it through this case. And that's part of why OCD has not, as far as I'm aware, taken any action one way or the other about the injection volumes.
So, Council, I do have a follow-up question then based on your submission. So if we do not have the evidence, how then can we say that Goodnight should cease their operation if, let's say, they are, or let's more or less make sure they are not doing any over-injection if we do not have any evidence?
Commissioner Ampoma, members of the commission, that is a good point, and that is exactly why I couched my advice as I did, because we do not know. And so all we can do is issue an order, which should be self-apparent, saying do not cease all over diversions. We're not shutting anyone down, but this commission may want to take strong action, as OCD counsel has stated, once all the information is in and we know the full extent of these over diversions as to penalties, whatever remedial action the hydrology may warrant as well. So I'm not recommending that we shut anyone down at this point. But if there is, by issuing an order today saying cease any over injections, if the evidence comes out that for some reason they continued, well, you want to know that too. And this will all come to light through the prism of the hearing. And so all we can do today is say stop it and hold everything else in abeyance. We would get a full accounting though at the hearing.
The OCD wants to add something else.
In conferring with my co-counsel on this, is the commission concerned about remanding this issue to OCD hearings? Is that what's underlying this? Just to kind of clarify things?
I would agree with Council Molander there that in this case, because we have pending litigation, we have a pending adjudicatory matter that this directly relates to. I could see why this was brought by Empire directly to the commission. rather than going through the division as an enforcement mechanism.
Commissioner Bloom, you look like you want to say something.
Thank you, Mr. Chairman. Yes, when the moment's right, I would like to hear a response from Goodnight Midstream and then Empire Council.
So council, just wanted to make sure we're not necessarily saying remanded back to the OCD hearings. We're just saying we don't know, we don't have any evidence to show that there's an over injection, correct?
Mr. Chair, members of the commission, correct. I'm not saying remand to the division. The commission has set this for a hearing.
Right.
The hearing is through the hearing officer who speaks, who is an extension of this commission.
Okay.
So there's no remand that I'm advocating for.
Okay. Does that answer your question, Mr. Moander?
Yes, thank you.
Okay, great. So should we proceed to hear the parties? What's the suggestion, I guess?
Well, I did find that the motion, the response, the reply fairly succinctly captured the issues as I've explained them. There might be some, but in the interest, if the commission wants to hear from counsel, because it is an interesting argument that we don't have any facts in the motion or the reply, an affidavit or some other discovery that was provided that would say exactly what the amounts are. We have not heard from Moonlight saying, yes, we have, or no, we haven't. So there might be something to be gained from that. It's up to the commission.
Okay, so then I'll just ask commissioners, do you want to hear the parties? I'll start with Dr. Mpoma.
Yeah, Greg wants to hear, so I also want to hear.
I know, Greg. I know Commissioner Bloom wants to hear. Commissioner Bloom, is that an affirmative?
Yes, and I think 5 minutes approximately should suffice. I mean, if people need more time, that's fine, but I would like to hear from both parties.
Okay, excellent. So the parties are present, correct? Pardon?
And I would start with the movement, Empire.
We'll start with Empire. Yeah,
Yeah.
I'm just making sure that all the parties are present. That's all. Okay, awesome. So let's start with Empire, please.
Mr. Chairman, members of the commission, my name is Ernest El Padilla, appearing for Goodnight with me, or Sharon Shaheen and Dana Hardy. We're counsel for Empire. I will be speaking concerning this motion today. And first of all, let me just say that I agree with Mr. Rubin's analysis of the situation. The only thing that he missed that I think is reporting. If we don't have any public records, OCD records of injection volumes from the Andre Dawson well, the Ernie Banks well, there's been no reporting on those two wells at all. But if you look at our motion, all of the wells that we listed there there's evidence of over injection. Now, I take it you want evidence on this thing, particularly those wells that are outside the unit, where we have to prove that there's going to be migration from those wells into the San Andres Formation. But when you look at this, all you see is an abuse of orders. For example, the allegation that we came up with, and that was based on discovery evidence, the evidence that was submitted to us in discovery by Goodnight. There, we finally saw that there was over injection, especially in the Andre Dawson is egregious to where you have 41,000 barrels a day when you have a limit of 25,000. And who knows what the pressures are. It seems to me that if you have a bottle of water in a confined area and you start pouring more water in it, the water is going to have to go somewhere. we're saying it's going into the Grayberg Formation, which is the producing formation for the unit. I mean, we won't go into residual oil zones at this point, but that is what Empire is trying to protect. We're confident that in September, we'll be able to show that there's residual oil zone, ROS, in the San Andres, and therefore it needs to be protected. Right now, with seemingly uncontrolled or excessive over-injection, I think the order of the commission, and the commission has authority to do that, is to stop the over-injection. That is one goal that we have. Now, we asked also to balance and suspend, but it doesn't seem like, from what I understand and Mr. Rubin's analysis, is that you want to wait until the September hearing to find out what the evidence will show. But the problem here is that you have overnight just simply in every well, there's over-injection. Some not as bad as others, but if you look at the allegations on the Andre Dawson well, I mean, that is really almost criminal in terms of, I don't know what the profit, well, I know it's a profit motive that drives that. But you can't exceed the order of the division in all of these cases where you're limited to 25,000 barrels a day and pressure, and you're going to have problems with pressure gradients and potentially fracturing the zone between the San Andres and the Grayberg. We're going to show that there are already natural fracturing in areas of the between the San Andres and the Grayberg. So to add pressures and add volumes, you're not going to succeed. It's going to impair the ROS in the San Andres. So to speak again, I think Mr. Rubin analyzed this, and I think the pleadings speak for themselves pretty much. Now, as far as the division is concerned, I don't know where they're coming from. If I saw a motion like that and I was counsel for the division, I would certainly try to find out whether or not those orders are being violated, instead of being in an adversarial situation where you want to prove something. I don't know where the OCD is coming from in this case. So the OCD should be looking at over-injection and try to find out if the allegations are correct. We're pretty certain they are correct. We wouldn't have put that in there without some basis and evidence that we obtained only through discovery, not through the public records of the OCD. We should have got it. We should have been able to get it from the OCD records. We don't have that.
Mr. Mohander?
I'll wait my turn
Okay.
on that.
I was,
I'm
you were
just
very
prepared.
insistent there. So, okay. Thank you, sir. Appreciate it. Good night now, right? Oh, doctor? The doctor has, should we wait till we're done or?
Oh, you always can. You're the
Okay,
commissioner.
go ahead.
So, Mr. PD, I do have one quick question and probably some follow-up. How do you define over-injection? Or how is Empire defining over-injection?
Through through evidence that we obtained in the litigation part of this case, we asked in discovery what volumes they were injecting. Now, some of them there is reporting at the OCD, but the Ernie Banks and this Andre Dussin, there's no reporting on those wells from date of first inception, from first injection into those wells. So it's hard to figure out where how much water there is or being put in the zone. In one instance, in a 4-day period, we were able to establish that it was 41,000 barrels per day. That's like 15,000 barrels over the limit, and you shouldn't do that. Does that answer your question?
Well, from a reservoir engineering standpoint, I want to see the fracture pressure for this particular formation, and then I want to see the allowable pressure that OCD gave in the order for me to more or less come to a conclusion whether you are more or less injecting above what the order is saying. From a previous hearing, OCD made clear that the pressure is the main item, that the main parameter that they go to, in terms of assigning what should be the maximum injection. So if I don't know what the fracture pressure is, it becomes very difficult to just make an assumption that just based on the volume, someone is injecting above the fracture pressure or more or less doing over injection.
I can tell you that the under Dussin maximum pressure is 862
Selfish.
daily. You can't exceed that pressure. The Ernie Banks, I think, is 867, and the Sosa well that we also have in there, it can exceed 900 pounds PSI injection pressure. Now, I don't have the information on the fracture pressure, on the fracture gradient, what will part the formation.
And I think that is certainly something that OCD has to be able to respond to.
Well,
Thank you.
If that information isn't available, and if you don't have any reporting on that, then that needs to be obtained.
Yeah.
Any other questions? Commissioner Bloom, did you have any questions?
No, thank you, Mr. Chair.
Dr. Pullman, any more?
No, not from the side.
Mr. Chair, just one question for Mr. Padilla. So, Mr. Padilla, why did you not submit any evidence that you were referring to from discovery or
Well,
whatnot
perhaps
as part of the motion?
we probably should have added discovery information that we got, or at least verified the motion.
Thank you.
Excellent. Any other questions?
Yeah, so council, even if they do not more or less submit any substantive evidence to support their claim, I think it is a matter of a concern that if that is happening, that the more or less OCD has to be able to figure that out and respond to these allegations.
I agree.
It's for more or less a public concern, not necessarily for Empire alone. It's a public concern if that is certainly happening.
Commissioner Palmer, members of the commission, if I understand Mr. Moender's response, OECD may not necessarily have had knowledge of this if a lot of the information was gained in the discovery process in the adjudication. I am not sure if they were able to monitor pressures in that in that region. I don't know if Mr. Moender would want to speak to that.
May I assume this will be my argument now in support of my reply or response?
We definitely can do that if we all agree.
Okay, so starting off, the nature of OCD's response was fairly straightforward and simple because OCD construed the primary issue in Empire's motion, focusing on the suspension more so than the stay, because the suspension would be a final determination. So OCD looked at the motion as being essentially a backdoor summary judgment without those terms ever actually appearing in the motion. For OCD's view, first of all, is we have a hearing set for this and OCD fully intends to participate, argue, ask questions. OCD has participated in discovery. We've had active litigation. The injection allegation is a more recent development that occurred within the confines of litigation. And from OCD's position, it stands to reason that since we have an active opportunity to conduct discovery, also we'll have an opportunity to examine witnesses and more importantly for this purpose, cross-examine witnesses, that's the forum where this evidence will need to be developed. I did not come today primarily, nor did I'll say in terms of my reply, there was no evidence provided in the showing from Empire's side that they could demonstrate the overinjection. OCD is also aware that there are filings that are currently pending concerning some of this material. Those filings have not been finalized from the OCD end, so there is information there. I cannot speak to whether that will have been fully processed by the time of the hearing or not. But when it comes to OCD's need to know about what parties are injecting, this is when you have the reporting structure, that's nice. But now we have the additional opportunity to actually ask some questions, develop evidence, and make representations to this commission and its hearing officer in about 6 weeks. Generally, it's not ideal to have parallel litigation ongoing. If you're conducting enforcement plus active litigation before the commission, I'll just say it bluntly, it's much easier to proceed with gaining information and knowledge through litigation like this than it is through traditional enforcement action. And so OCD is pursuing this litigation. And if evidence ultimately does show that there is overinjection, then OCD would evaluate that for potential future enforcement purposes. So back to the original motion as it's been presented today. No, I did not come prepared to provide exhibits or anything of the kind because there were none to really respond to. It was mostly legal argument and allegations. And so OCD's position is we very much would like to proceed with this hearing at the end of September so we can fully learn the contours of both parties' cases and their evidence.
Thank you, Mr. Moander. Any questions from the commissioners?
Not from my side.
Commissioner
No,
Bloom?
Mr. Chair. No, Mr. Chair.
Excellent. Thank you. Good night, please.
Morning, Acting Director Rosados, Commissioners. Thank you for the opportunity to speak. We've heard this morning and in the papers that were filed by Empire some very serious allegations verging on criminal this morning. And we take these allegations very seriously. And I'd like the opportunity to rebut everything that was said this morning. In fact, we have some images to show to allay Mr. Oma's concerns about pressures, about what has occurred. And I think I'll like to take some time to clear the air and put this into context a little bit. The motion that they filed happened to have been filed when I was on vacation for 3 weeks. So I didn't have a lot of time to respond to it when I got back. But our response was limited to mostly legal arguments because counsel and Empire did not file any exhibits or any evidence substantiating their claims. If I may, I'm just going to walk through this very quickly because I think it would be helpful. It goes into the context here of what I want to say and review for the commission. If I can share my screen. Number one, Mr. Rubin, I do want to make clear that in response, Goodnight does deny the allegations that were raised by Empire vigorously. Now it's a general denial of the allegations because there was nothing specific to respond to in terms of evidence. So if they had presented us with some evidence to directly attack, address, we would have done so. Instead, they didn't, and they relied on the argument of counsel. So we did not see the need to attach any evidence or specifically rebut their claims. Under the commission's precedents and guidance, when you're seeking a stay or suspension or of an order of the division or commission, the commission has very clear guidance. It's a high threshold. They cite to the Tenneco Oil Company case. The requirement is to, sorry, I wish I had my mouse. You have to make several showings. You have to make showings, which means you have to present evidence. You have to show that you'll likely prevail on the merits. You have to show that there's going to be irreparable harm unless the stay is granted. You have to present evidence that no substantial harm will result as a result of the stay. You have to make a showing that no harm will ensue to the public interest. All these things were not done. They also have to show under the commission's own regulations that a stay is necessary to prevent waste, protect relative rights, protect public health, and prevent gross negative consequences to an affected party. So what is it that they're claiming here, and what has the commission done? The commission has very clearly in the past required clear showing, evidentiary showing of what is necessary to overcome, that you're likely going to prevail on the merits of the claims. When that hasn't been done, when there's been no evidence shown, then those motions to stay are denied. Here, again, they've submitted nothing. They rely entirely, we've provided them lots of evidence in the record, pressure data, injection volumes, all that has been produced to them and to the division. So mere allegations of counsel, as we understand from Tenneco, is not sufficient to demonstrate their burden. So let me just address the specific issues here, okay? What would they need to show? Well, they're going to need to show that the injection is causing waste. To do that, they have to show that the wells that Goodnight is operating tend to reduce the total quantity of oil or gas ultimately recovered from a pool. They have to show what the amount of oil or gas is that can be recovered and that we're causing an impairment, the prohibition of them from recovering that amount, okay? That's a pretty big showing. They haven't even attempted to make that showing. Number two, they're saying that we're harming their correlative rights, okay? To make that showing, you have to demonstrate that there's recoverable oil or gas, okay? They're claiming that we're impairing their correlative rights in the San Andres, where they're alleging an ROZ, a residual oil zone. So to make that claim, to say that we're actually impairing the correlative rights, they have to show that the gas down there is recoverable, technically, feasibly, reasonably. Not only that, but under the correlative rights, under the enumeration of power statute, which defines the commission's authorities, they're alleging that we're watering out the unit strata. Well, what does that require what do they need to show to prove that? They need to show that the strata are capable of producing and paying quantities. They have to show that the San Andres ROZ that they're alleging exists is capable of producing and paying quantities, and that our injection tends to reduce the total ultimate recovery from that pool. So they have to show how much could actually be recovered, and they need to show that they can produce it in paying quantities in order for them to show that we're watering out that zone. They haven't even attempted to make that showing at all. And so for those reasons, they cannot prevail on this motion. Now, the allegations that they raised are serious and concerning, and everybody agrees, including Goodnight, that if there are continuous overinjection issues, that they need to be addressed. In fact, Goodnight self-disclosed to the division more than a year ago that it had discovered itself that it was overinjecting in the Andre Dawson well. And it disclosed the reason for that overinjection was due to a malfunctioning meter. So back more than a year ago, at the end of May, early June, Goodnight submitted a disclosure to the division through council and the UIC group that had discovered that it was overinjecting for a period of time in the Andre Dawson. Explained what it found, the efforts it made to correct the issue, and that was more than a year ago. Okay, so that was disclosed by Goodnight and more than a year ago. The reason that Empire hasn't been able to identify the C-115s that would normally show the public reporting volumes is because the completion reports, the C-104 and C-105s that are required once a well is drilled, you need to get those approved before you can physically upload the C-115 reports, the volumes and the pressures that go along with your monthly reporting requirements. So the division has not yet approved those. They've been with the division for some time. Goodnight has been actively engaged with the division to try to get those approved as quickly as possible. They have in the interim provided the division with email of the C-115 reports identifying all the volumes and pressures. As the commission may or may not be aware, has been a substantial backlog in these completion report approvals from the division. There are a lot of them. It does tend to impact public reporting about not just injection volumes, but also production volumes as well. So that is the issue for those two wells. The reason that you're not seeing those volumes publicly is because we have no way to upload them into the division system because the C-104 and C-105 haven't been approved. Once they are approved, then the system allows for the volumes to be uploaded. So the division is aware of those issues, and we've been working with them for more than a year to try to get that resolved. The injection issues, in their motions, they allege that all these wells have limits of 25,000 barrels of water per day. In fact, it's real easy to look at the orders and you'll see that actually 4 of them have no limits whatsoever, and they're entirely based on the pressures. Okay. Now, more recently, the division has, over concerns of induced seismicity, especially in the deeper Devonian when you're closer to basement rock, have imposed some rate limitations for high capacity disposal wells. Now, the concern around those higher rate wells is generally limited to the Devonian, where you've got basement rock. I understand there's some scientific papers and research that indicates that for those deeper formations, rates can influence induced seismicity, even though the injection pressures may not be an issue. So the division has instituted more recently rate limits on some of the SWDs. I'm going to explain a little bit for you on that because I think it's helpful to put this all in context. The way the rate limits came up for the Andre Dawson and the Ernie Banks is that when Goodnight filed its C-108 application, which is this snippet up here showing what they proposed, they initially proposed 25,000 barrels per day for the Andre Dawson and the Ernie Banks. The reason they chose that number, as you will hear in about a month, is because 25,000 barrels per day is more than what they inject on an average basis in a month. Okay, that is generally more than enough to manage their injection rates. The issue is, and it's becoming more of an issue now as we move into more modern well completion practices, is that Goodnight experiences surges of disposal volumes. More commonly now, operators out in the field are completing their wells in batches. So rather than drilling 1 or 2 wells and getting flow back from 1 or 2 wells, they're doing batch drilling. So when Goodnight first permitted these wells, you get batch drills for 4 or 5 days, and you get a slug of water over 4 or 5 days. Now you're seeing batch drills that take 2 weeks or so to complete. So you're getting more wells, you're getting longer laterals, and you're getting more flowback water. So you get more volumes in a big slug. Goodnight's practice has been to disperse the flows to as many wells as possible over an area. So they have a central receipt point on their pipeline. They monitor the flows, they treat the water, they put it out to their multiple SWDs to manage the volumes and pressures. So they have initially identified 25,000 barrels as enough. And in fact, the 4 wells that are currently injecting into the EMSU since January 2023 have averaged less than 15,000 barrels of water per day. Okay, that's the average for the 4 wells injecting into the EMSU. So well under the 25,000 barrel per day limit. Same thing here with Ernie Banks. This just shows you, what was initially proposed, what the order provides for, and you'll see that it does provide for 25,000 barrels with the rates and the pressures. So those are the only two wells out of all the ones that we're being accused of here that have an injection limit. And as I mentioned before, we've already self-disclosed on the Andre Dawson. As a result of the allegations here, we went through more recent injection volumes and did identify a few days for the Ernie Banks that have exceeded the 25,000 barrel limit. I understand that there is a valve issue that may have caused that. It's a few thousand barrels exceedance for a couple of days. But I'm going to show you at the end here to address any concerns about what, I mean, we take this very seriously, obviously, because Goodnight self-disclosed when it did go over, and the intent is to make sure that they are in compliance. Goodnight takes it very seriously. Now, this is just to sort of explain again the context here. The 25,000 barrel per day limit was proposed by Goodnight. It's not a technical limit, merits-based limit. It's not a limit that's tied to pressures. It's simply what Goodnight proposed. The division adopted it when it issued the orders. And for one of the wells, the Andre Dawson here, we're actually asking for an increase as part of these cases just to accommodate the spikes that occur on occasion so that we can make sure that we're staying within our limits. Okay. Now, what does this look like in terms of pressure? Okay, we 100% agree with Dr. Ampoma that the issue here is about pressures. So this is a chart that shows back from January 2023 to about the present for the two of the wells that have the injection rate limits. The squiggly lines here are the surface injection pressures. Okay, you'll see that they tend to be very low, and they bop up and down here and there. Okay, and you'll see that for the blue line here, that's the Ernie Banks. There are some higher points up here. Okay. Now, what is the limit that the division has imposed? Okay. Well, you look on the left-hand side on the y-axis, that's the PSI. You'll see the limits are way up here. Okay. The Dawson is at 857. The Banks is at 862. We are far below those limits. And the reason you're seeing some of the spiking here is simply because of scaling. Scaling is a common occurrence with saltwater disposal wells. As scaling occurs, Goodnight periodically will acidize its wells, and you'll see they just acidized at the end of July. After they did their acid test, acid clean out, the wells both went back to vacuum, okay, despite their injection rates. In other words, there is no impact to the reservoir. The reservoir is receiving these volumes on vacuum, meaning there's zero pressure buildup in the well. Now, on the point that Empire made, they're seeking relief. They want us to suspend or stop injection until, on the assumption, I presume, that we're injecting continuously over the volumes here. And so they're asking for Goodnight's wells to be shut in until the net the overinjection is balanced with the amount of authorized injection. Well, here, if we've given them the data, and they would be able to see that if you put this data on a plot, you'll see that for both these wells, we're actually under by more than 5 million barrels. I mean, if you were to ask us to apply that relief right now, we could continue to inject because there's no issue. I mean, every day we're under injecting on average what the total volumes are under these wells. So not only was there no evidence, but the claims, I think, are unsubstantiated. There are a few days that have exceeded the injection rates. Goodnight takes it very seriously. They're addressing those issues. In one case, it was a metering issue from last year. We self-disclosed that. On the Ernie Banks, there were a few additional days that had a different issue with the valve. And Goodnight, as I understand, has completed that. Fixing that issue, that was back in 2023. My understanding, and we'll provide all the data to Goodnight, to Empire and to the division, is that there have been no further exceedances of the ejection rates. So Mr. Acting Director Rosados and Commissioners, we ask that this motion be denied. These issues all are going to be heard by the commission in a month. They can continue to raise their allegations about overinjection, overpressurization, or communication with other zones, and we'll address them in the full course of that hearing. Rather than present the data to the commission for us to actually respond to, they just relied on allegations. We take those very seriously and want to have a full hearing and airing of all these issues in September.
Thank you, Mr. Rankin. Any questions from the commissioners?
Mr. Chairman, may I respond?
Please.
Mr. Rankin makes an interesting argument about injection rates and volumes and that kind of thing, and he throws in the Devonian here. And that one's particularly interesting because the Devonian has a disposal interval between 1,000 and 1,200 feet of disposal zone. That's not the case with the San Andres. And the Devonian has nothing to do with the Devonian. The Devonian is not even relevant to this proceeding. He talks about the C-115s. They have never been produced to us in discovery. And I don't know why, but we haven't received the C-118s that they have in their pocket somewhere. So, and then he talks about surges. If you have surges, you got to do something about evening out those surges. And that means reduce injection volumes so that you can even out and not have the surges. The question, the issue of whether or not a meter was inoperative, we don't know that. In their response, they never addressed any of this information that Mr. Rankin has submitted here. If you look at their response, they go a lot into, we had to respond to their argument on injunctive relief. It probably has something to do with it here. I mean, we're talking about a stay. We're asking for a stay and suspension. Is that what we're doing? And yes, a lot of this evidence is going to come in September, but to the extent that we didn't file this motion just for the frivolity of it and trying to be argumentative. I mean, what we saw is based upon information that we had. So if Mr. Rankin has C-115s in his pocket somewhere, then those should have been produced to show in the response that our allegations were misplaced. So I don't know. We can go argue all day long on this thing, but I think Mr. Rubin's analysis is correct, is that somehow there has to be an accounting and it ought to come before September. The issue here is over injection. It's not the merits of whether there's RAWs in the San Andres or correlative rights. We're talking about existing orders that we see are being over-injection, where there's over-injection, a systematic practice that should be addressed by the commission. And I think the accounting should be coming. I mean, that's an order that the commission can issue at this point.
Okay, thank you. Just to make sure, just so we could have questions for good night. I know Dr. Mpoma, you seem to have some questions as well. Commissioner Bloom, you may also. So go ahead, Dr. Mpoma.
Oh, Mr. Chair, if I could quickly, Mr. Rankin, if you're done sharing your screen, you could perhaps pull that down.
There we go. Thank you, Mr. Rankin.
No, I really wanted that screen. I really wanted a presentation up. So if you can bring it up where you have the pressure. Sorry about that. So the next one, the one that had the pressure. So Mr. Padilla, I do have a quick question for you, and the same for OCD as well. So as you look at this data, is Empire challenging this data based on the information you have?
We can't challenge it today. We've got to look at it. It certainly would have been helpful to have had it in the response, but we didn't get it in the response.
So I'll have
Matter
the
of
same.
fact, we got nothing in the response in terms of refuting any of the allegations that we had. If you take all 6 wells that we cited in our motion, there was no answer to those allegations. It seems like maybe the answer to your question on pressures is addressed by that slide on, and if that's true, I don't know. I don't know what the pressures that were reported. That's not backed by anything other than a graph that somebody wrote.
I think to be clear, if I may just add to what Mr. Padilla has said, none of this information is evidence in the record. This is the first time we are seeing it here today, and Goodnight has failed to produce the C-115s in response to discovery request after discovery request. That's the first time we heard today that those exist. So I think that's our issue with the presentation. We haven't seen this before.
Commissioner Ampoma, members of the commission, I think Ms. Hardy is correct. I do ask that we kind of limit the argument to 1 lawyer per party. We don't want to double team Mr. Rankin here. But regardless, that point is taken. Mr. Rankin, members of the commission, has provided a lot of substance here, but nonetheless, it is still just a lawyer talking. And he is not pretending otherwise. There is no evidence before this commission. And I know, Dr. Ampoma, you want to get at the truth, but it would be unfair to either side to get at the truth based upon what lawyers have said today.
Okay. That's I'll rest my case.
Which is why I am advising that the motion either be held in abeyance, or perhaps it could be denied without prejudice. But we do need the hearing officer, I think, to, as part of its findings, make a recommendation to this commission as to whether the permit has been violated. Mr. Rankin, go ahead.
I thank you. I just want to address another allegation that was made. Empire did not ask for the C-115s to be produced, and the C-115s only would show monthly volumes. Okay. What they asked for were the daily volumes, and they asked for the daily pressures. So we gave them more than what would be discernible from the monthly volumes themselves. So if you were to look simply at the monthly volumes, you may not, as I said, because the monthly average injection rates are around 14,000 barrels per day, they may not have discerned that there was ever an overinjection. Okay. So we gave them all this data, including the pressures, and I can't tell you exactly the date it was up to, but it was up to around the end of 2023. So they have all the pressures. They have all the rates up to that time frame. We're going to supplement up to the end of July. So they have all that as well. And I just want to make very clear that actually they did have all this. They had more than what the division would have had it been filed publicly.
Thank you, Mr. Rankin. Commissioner Bloom, I wanted to give you an opportunity as well. I mean, in light of what Mr. Rubin said, did you have any questions?
Yes, thank you, Mr. Chair. So just sort of to recap, I opened this can of worms by wanting to make sure that OCD would fundamentally be okay with an order potentially coming from the commission, and essentially bringing this issue now into this case. And we heard that the OCD is okay with that, not wanting to explore these issues during litigation, as we heard from Mr. Moyander. So I heard that. I would just note that I guess now every allegation between parties will become part of the case. I'm wondering, maybe some questions for Mr. Rubin. We heard from Mr. Rankin about Tenneco might have some bearing here. And I'm also wondering if in order at this point from the commission not to overinject would serve a purpose, and that all companies need to obey their permits and state laws and regs. And also, Mr. Rubin, would an order be seen as prejudicial or become prejudicial in some way?
Commissioner Bloom, members of the commission, an order, as I recommended, that would simply state that all overinjections in violation of the permit cease would not be prejudicial. It is simply restating what should be already understood by all operators licensed by the commission or the division. So from what Mr. Rankin has presented, Commissioner Bloom, there might even be some dispute as to what the permit says that they can do, as to what the limitations are, whether it's daily, monthly, what the exceedances, how to calculate exceedances. So that's why I would simply want it to be sort of a conclusatory order from the commission today, stating do not violate your permit. And as to what that is, we will find out after the hearing in September. But it is important that we get to the bottom of whether there was a violation, and we'd want a recommendation from a hearing officer on that. As you can see, Commissioner Bloom, it is a rich tapestry as to whether what the permit says and whether it's been violated.
Thank you, Mr. Rubin. Commissioner Bloom, anything else?
That's it. Thank you.
Excellent. Dr. Mpoma?
No, I'm okay.
Okay, so
I'm
sorry. There is the OCD, please.
As a matter of record, because I do believe these things are important, and this is related to the motion, but not the substance. And I didn't get to mention it because things got right into the fist fight early this morning. OCD is going to withdraw its section 2 of its response. It turned out there was a major IT problem with email, and I, as the attorney, made an allegation that turns out to be a little incorrect. And so I wanted to withdraw that on the record and make that clear so there's no confusion.
Okay. Thank you. Appreciate that.
So quick one. So counsel, we are not really admitting what Mr. Rankin showed us today as part of the proceedings, right?
Commissioner Mpoma, that is correct. We are not deciding anything. We are not admitting it. There was nothing to admit in terms of evidence. Again, lawyers can, as erudite as the Grafs may be, and Mr. Rankin may be, he's just still a lawyer. And so we are not admitting anything today. And I mean that I'm not, don't mean that pejoratively, Mr. Rankin. You're a better lawyer than I, but nonetheless. So all I suggest that we commission you today is, if it wishes, it can order today that the permit be adhered to, be any over injection cease as defined by the permit, whatever that is, and to direct the hearing officer to include his recommendations whether the permit has been violated, and to hold in abeyance any further action on the motion, not decide it today. So that's what I recommend the motion be. Can I get a so moved?
But I move it.
Okay. Do I have a second?
I second.
So it is ordered.
We will need a roll call.
We need a roll call. Okay. Dr. Mpoma.
Approved.
Commissioner Bloom.
Nay, and I would like to say I don't know that an order is necessary at this point, so I am not voting in favor.
Okay. And I approve.
Okay. Motion passes 2-1. I will draft up an order for the chair's signature later today.
Okay.
And so with that, any other matters on this agenda item from the parties?
Mr. Rubin, we need some clarification, and maybe it's already in some form, but council and I were talking yesterday about the the hearing examiner, well, we were wondering if the commission was going to be present during the September hearing or just the hearing to the hearing examiner.
Mr. Padilla, I do not know the answer to that myself. I think it is at the pleasure and discretion of the commission to delegate to what extent it wishes to the hearing officer, examiner.
And would there be a report from the hearing officer recommending a decision one way or the other? Do you know, or that's not decided yet?
Mr. Padilla, it was my understanding that the hearing officer, Mr. Harwood, would provide a recommendation, proposed findings and conclusions to the commission. Is there some rule you're aware of that would preclude that?
No. I was just wondering whether we were going to submit requested findings and conclusions and that kind of thing.
Yes, Mr. Padilla. The hearing officer, with all administrative adjudications.
Mr. Rubin, I'm just going to interrupt a second. There must be some IT glitch on our end. On Teams, we're still streaming, so I can see us on Teams. So we are proceeding. Sorry.
Just Open Meetings Act compliance. Are people able to hear us, members of the public?
Commissioner Bloom, can you hear us?
Yes, there's been no interruption on my
Okay.
end.
And can you see us?
Yes. I can
Okay.
see them right now.
Oh, there we go.
So to Mr. Padilla's point, hearing examiners sometimes will ask for the parties to submit proposed findings and conclusions before concocting their own. That's up to him. So we would expect a report from him that this commission would then be able to digest.
And finally, we were also wondering if how we're going to split up time, on who goes first, that kind of thing. And that's probably something we need to talk to Mr. Rankin about time limitations per witness and time limitations on cross-examination.
Yes, Mr. Padilla, we are delegating those procedural matters to Mr. Harwood, but I'm sure he would welcome some consensus from the parties on those procedures.
So if we had some concerns about that, we would deal with Mr. Harwood.
Correct, Mr. Padilla.
Okay.
And Mr. Chair, Mr. Rubin, to my knowledge, I believe the commission has typically sat through the discussions and asked questions during hearings where there is a hearing officer. That would be my preference. I just wanted to put that out there. I don't know if there's a consensus among the commission or how we'll handle that.
If I may, thank you, Commissioner Bloom. All I would ask is that the commission can be polled separately from today. If a quorum of the commission wishes to be present for the hearing, we do need to comply with the Open Meetings Act. That is the only constraint that I am concerned about.
Yeah, Mr. Rubin, I remember when we were setting the date, I remember the commissioners were going to be present. So that was my understanding too.
Very well.
Okay. Any other points on this particular matter?
I'll just say that, Counsel for Empire raised this question with me this morning. I think it's appropriate to confer among the parties and then coordinate with the hearing examiner outside of the commission's meeting. I think we can do that and should be able to come to agreement on how to manage the procedure.
And OCD joins in that and agrees as well.
Okay. Mr. Padilla?
That's fine.
Okay.
Mr. Chair?
Yes.
May I be heard briefly?
Please.
I'm Miguel Suazo, and I'm representing Pilot Water in a matter that is impacted by the matters that are before the commission today. And since we're talking this procedural grounds, I just wanted to flag for the commission that Pilot Water would like to participate in the hearing in September. The nature of that participation is going to be limited in scope, but essentially what I wanted to flag for the commission is that Empire's filed essentially similar, complaints against Pilot as it has against Goodnight. Specifically, they're challenging Order SWD 1750 and in Order R23254, which was issued on June 26th. They essentially stayed Pilot's matter pending the outcome of these proceedings today and the hearing in September. And so Pilot would just like to ask to be included with the discussions with the parties and the hearing examiner so that they can participate in September, potentially furnish a witness, although no decision has been made, but most certainly to impart testimony to the effect, or at least a statement to the effect, that they are supportive generally of Pilot's position in terms of its take on the impact to the EMSU and the San Andres in this proceeding, which stands to impact Pilot's interests in the San Andres outside of the EMSU.
If I may, Mr.
Please,
Chair.
Mr. Rubin.
Mr. Suazo, I don't have the rules in front of me, but has there been a formal intervention by Pilot?
Well, I would need to go back and look at the filings for this particular case. I know that Goodnight has intervened in our case, and there was testimony from before the division about the fact that these matters are related. I don't think that they've been formally consolidated, but they're nevertheless interrelated, which is why they were stayed. So if that is a procedural matter that needs to be undertaken, I suppose we should discuss that and decide if that is something that, for purposes of record keeping, the commission and council would like to see, just so there's no issues once the hearing date is actually upon us.
Yes, Mr. Suazo, I think you'd be well advised to consult the procedures on this in the rules as to what you can do and cannot do without intervening. I'm sure that the other parties may have opposition to you participating without something formal from your client. Thank you.
Thank you.
Excellent. Anything else on this matter? Okay.
Commissioners, this is Matt Beck on behalf of Rice Operating Company and Permian Line Service LLC. We stand in a similar position to Pilot. We have intervened in this matter. And so we're in the exact same position. Empire filed applications. They've moved to dismiss them, but because of the commission stay, they haven't been dismissed. So we'll participate in I would think, a parallel manner with Pilot in a like manner, and make sure that we're included in those discussions as well.
Correct. Thank you, Mr. Beck. I think what Mr. Rubin said applies to you as well. So thank
Certainly.
you. Excellent. Okay, so this matter is complete.
Yes, Mr. Chair, I would advise that we move on to the next agenda item.
I think we also need a little break. So how about we take a break? Let's take a 10-minute break. Thank you, everyone.
Not there, 8 o'clock. August training. What's that?
Back in order here. Our next case is case number 24683, application of Western Environmental Law Center Citizens Caring for the Future Conservation Voters of New Mexico Education Fund, the Dene Care Earthworks Naiva, New Mexico Interfaith Power, Light, San Juan Citizens Alliance, and Sierra Club to amend 1915.2, 19.15.5, 19.15.8, 19.15.9, and 19.15.25 NMAC. Are all the parties present for this particular case? Excellent. Great. Mr. Rubin.
Mr. Chair, this is Andrew Cloutier. I'm here on Teams, not present.
Excellent. Thank you, sir.
Mr. Chair, members of the commission, at this point, it would be appropriate to have the petitioner, the parties seeking to have the commission initiate this proposed rulemaking to address the commission, make a presentation, mindful, of course, that this should not be too substantive in nature, as ultimately a hearing would resolve that, a public hearing. Thank you.
Excellent. Thank you, Mr. Rubin. So who would like to start off? I can barely see you. Sorry. Sure. There you go.
There you go. Good morning and thank you all. I'm Allie Beasley, counsel for applicants, and here with me today are my co-counsel Kyle Tisdale, Morgan O'Grady, and Tannis Fox over there. As you all sort of outlined, we are seeking to amend 19.15.2, 5, 8, 9, and 25 in MAC governing definitions, enforcement and compliance, certain financial assurance provisions, well operated provisions, and well plugging and abandonment. New Mexico needs an effective regulatory scheme in order to facilitate plugging and abandonment of wells when they reach the end of their useful lives, and to ensure that the state and its taxpayers don't bear the costs of orphan wells. And currently, the commission rules allow operators to post financial assurances that fall short of the actual costs of plugging and cleanup. And when wells reach the end of their useful lives, those wells need to be sort of properly plugged and abandoned. And this discounting of that cost creates a significant gap between total estimated costs for the state to plug all of its oil and gas wells and what actually is available for that purpose in funds held by the state for financial assurances. And the current rules also allow operators to keep wells in temporary abandonment status indefinitely. And this creates risks for the state and its taxpayers and our communities, environmental and financial risks, when these wells can sort of linger in temporary abandonment and are at increased risk of becoming orphaned without any demonstration that the wells will return to beneficial use. So these proposed amendments seek to address these regulatory gaps and the attendant health and environmental and financial risks. In preparing this, we consulted with staff from both the Oil Conservation Division and the State Land Office about our scope and language of our proposal, and we really appreciate the willingness to meet and their input. And likewise, prior to filing the petition, we met with representatives from NMOGA, IPA&M, and the Permian Basin Petroleum Association to give them notice of our filing. And we look forward to continuing conversations with all parties here and hope to work with the parties prior to hearing, if hearing is granted, to try to find common ground and narrow the scope of the issues further. Today, we respectfully request that the commission schedule a hybrid hearing on this matter beginning April 7th, 2025, and continuing after as necessary. We anticipate needing about a week for the hearing, but of course, that's up to the commission and it could go longer. We had originally requested a hearing date in October, and then when we moved this meeting forward from July to August, we're looking at December. But in order to accommodate other Oil Conservation Division hearings coming up this year, commission hearings, and the upcoming legislative session during which the commission typically does not meet, we have proposed to move that date to April 7th for the start date for the hearing, and filed an amended proposed notice to that effect earlier this week. And we also request that the commission issue an order appointing a hearing officer in this matter and requiring that the parties file each witness's full direct testimony and exhibits by January 31st, 2025. So that would be 2 months in advance of the April hearing date, if it were to be April. And then each witness full rebuttal testimony a month in advance of hearing date, which for an April 7th hearing would be March 7th, 2025. And we request that full direct and rebuttal testimony rather than the concise statement of testimony is contemplated in the rules at 19.15.3.11b2, so that the parties and commission have a full understanding of the evidence prior to hearing, and we can present a more fulsome record for decision at hearing. This is something that we have seen in the Water Quality Control Commission, Environmental Improvement Board, and PRC hearings, and so we are proposing the same here. And it's my understanding that a similar process is happening before the commission in the PFAS hearing later this fall. So yeah, thank you for considering our request for hearing, and I'd be happy to answer any questions.
Excellent. Thank you.
Ms. Beasley, I apologize. I'm having some issues with my laptop. Do you have a hard copy of the strike-through red line version of the proposed rules? An extra copy?
Would you like?
Yeah.
It's not in red, but it does have the strike through. So it's starting here. Oh, I can extract it. You have one? Okay.
Mr. Chair, members of the commission, I would advise that we hear from anyone else, any other interested parties before we hear from the commission.
We'll just go down the table from.
Looks like
Left
that's
to
what we're going to do.
Okay, awesome.
Thank you, Mr. Chair. Good morning, commissioners. My name is Miguel Suazo. I'm with the Santa Fe office of Beatty and Wozniak, joined today by my colleague, Caitlin Luck. And we're here today representing the New Mexico Oil and Gas Association, also known as NMOGA, which consists of over 200 member companies operating in New Mexico who help support our state schools, including producing almost $14 billion in 2023 alone. I'm pleased to be here today on behalf of NMOGA. And I'm here because NMOGA's position on this rulemaking and the need for a hearing is clear. NMOGA opposes a hearing on these proposed rules. And the reason why is because these rules, as drafted, do not fit the needs of the industry. These rules demand additional clarity and flexibility. Good rules must establish clear, cost-effective, and performance-based standards. These rules do not achieve that. Rules must provide flexibility for operators and for the commission and the division. They should allow for operational flexibility without imposing rigid constraints. These grids do not achieve that purpose. Rules should also not overburden those who are required to abide by them. NMOGA opposes generally rules that are overly burdensome, duplicative, redundant, impractical, and ineffective. That is what these rules are. Now, it's important for the commission to understand that these rules will impact industry differently, especially smaller oil and gas businesses. And these are businesses that generate value for our state's economy that are impacted. There's a financial burden associated with these rules that will force companies, large and small, to bear significant costs, not only to ensure compliance, but also to navigate their onerous and expensive requirements. These rules will create compliance and operational challenges. And that's because these rules are unclear and impractical. And because they are impractical, they'll also be difficult for this commission and OCD to implement them. So bottom line here, broadly, which is what you've requested today, these rules need drastic refinement. To be practical and meaningful, the rules need substantial revisions to align with industry realities and avoid unnecessary strain on New Mexico's businesses. And finally, as you heard the applicant's counsel say, they let NMOGA and IPA&M know that these rules were coming, but they didn't collaborate with industry to make sure that these rules made sense from an industry perspective. So this rulemaking unfortunately arises under unfortunate circumstances. The initiation of this rulemaking could have been more effective if it were approached with greater collaboration. This rulemaking was pursued without industry engagement. There was no consultation with NMOGA, the state's largest oil and gas trade association. So this is really a missed chance for partnership with the applicant. and a valuable opportunity that was missed to work together. And as a result, these rules, as anybody who's worked in this industry for any number of years, can see that these regulations reflect a lack of industry perspective and expertise. You know, NMOGA is dedicated to industry improvement, and anyone who's worked in this industry knows that oil and gas operations have functioned better in recent decades than they did in decades prior. NMOGA would have preferred a cooperative approach in this rulemaking, but instead, because it would require so much work to make these rules make sense for the industry itself, NMOGA has to oppose this rulemaking and opposes any hearing on these rules. And if any rules are passed, industry should be involved from their inception before they are filed. Instead, today, NMOGA is here in a reactive position, formulating is placed in a reactive position that's neither productive or conducive to the industry's growth, and that taxes the resources of the agencies charged with regulating NMOGA's oil and gas industry. And because of that, NMOGA opposes these rules, opposes this rulemaking, and opposes any further hearing on these rules. Thank you.
Thank you, Mr. Suazo. Appreciate it. Mr. Tremaine.
Thank you, Mr. Chair. My name is Jesse Tremaine. I am the legal director for the Oil Conservation Division. And the OCD is here today to, as a general matter, to support the amendment of the reference rules. We do agree that there may likely be necessary changes and modifications to the proposals as the parties work through this process to refine the rule. But we do see that as a matter of refinement and logical outgrowth rather than going back to the drawing board. I do unfortunately have to disagree with Mr. Suazo. In my opinion, this has been a highly collaborative process, not the draft of this particular rule, but all of the parties present were party to probably something like a 6-month stakeholder engagement process related to proposed amendments starting in 2023 to the Oil and Gas Act. Now, you will see that there are, if you review the legislative proposals as opposed to Welk's petition to amend these rules, you will see that they are somewhat different, and that is the necessary nature of taking the critical aspects of what were proposed and discussed over a period of months between all of those parties to that stakeholder engagement and applying it to the current existing statutory authority. So we're inherently dealing with a different proposal because we're talking about modifying rules under the existing statute as opposed to modifying the statute. But additional changes to transfer requirements, modifications to financial assurance, inactive well plugging. These are all issues that the state and the Oil Conservation Division have made numerous public presentations regarding, and our position has been clear and quite detailed regarding the inactive well and financial assurance liability posed to the state, and the demands placed upon the current reclamation fund and available BIL funds. So we do support some form of the current proposal, and we'll eagerly work with all of the parties present in the case. We support this going forward. OCD has reviewed the draft notice presented by Western Environmental Law Center and provided some initial technical wording feedback. And we've also recently received some proposed edits and comments on that in a comment form rather than a red line form, but that is helpful from the from IPA&M. So given that there is some additional feedback on that proposed notice, I am proposing to the commission that it might be appropriate to allow the parties to consider that input, provide a deadline by which the parties can submit a stipulated, either stipulated notice or a stipulated pre-hearing order, such as we did during the last rulemaking that's currently underway, PFAS rulemaking. that is at the pleasure or direction of the commission. But I think those are alternatives that will allow the parties to work through some of the procedural questions that were presented in the filing this morning by IPA&M. And I think that could be processed relatively quickly. And the last thing that I will comment on is just as a procedural matter, OCD has proposed in discussion with all of the parties, after discussion with all of the parties, we have proposed April as a potential rulemaking date, April 7th, or frankly, anytime in April works for the division because of our witness and legal resource availability after session. We think that that would work. We do have some limitations in terms of May to push that out. Critical staff will be out during that period of time. So in summary, we think that there is a lot of record and a lot of history and a lot of engagement here. It is critical, absent some change during a legislative session, to address the liability presented by the state of matters on the ground in New Mexico and the current language of the rules. And we support this rulemaking petition going to hearing in April.
Excellent. Thank you, Mr. Tremaine. Mr. Felderwart.
Good morning, Mr. Chair, members of the commission. Michael Felderwart, Santa Fe Office of Holland and Hart on behalf of Oxy USA Inc. Oxy does not take a position on whether you should hold a hearing or not. I do have some comments, I guess, on the filing by Welk on the proposed notice of hearing. One would be a request that if we're going to spend your time and our time and all this money on any rulemaking, that if you're going to present a technical witness, that technical witness be here so that you can have more effective examination of that witness. That would be my first proposed suggestion. Secondly, to avoid any surprise, if we do have a hearing, that not only technical testimony and exhibits, but any exhibits that would be considered non-technical, whatever that necessarily means, that those exhibits be filed in advance of the hearing, not on the day of the hearing. We don't know what those exhibits would be. Nobody wants to be surprised. It's not too big of a burden to ask someone who wants to present non-technical exhibits at the hearing to file them ahead of time. We did that in the procedural order for the PFAS rulemaking. I think it makes a lot of sense. So if you're going to have a hearing, those would be the two changes that I would suggest. One, technical witnesses be here. I'm not talking about non-technical. I'm not talking about public comment. I'm talking about technical witnesses, that they be here for effective cross-examination. And then secondly, that any exhibits that people want to file, that they be filed ahead of time with the parties in the commission, so we have no surprise.
Thank you, Mr. Felderwart. And Mr. I don't know, remember how you pronounce it, Mr. Coultier or Coultier?
Cloutier, but I've been called worse. So.
Okay, I apologize.
No problem at all. Good morning, Mr. Chair and members of the commission. Andrew Cloutier of the Hinkle Shaner firm, representing the Independent Petroleum Association of New Mexico. Like NMOGA, IPA&M strongly opposes the rulemaking on three primary bases. I'm not going to repeat Mr. Suazo's comments about the needs for refinement and more collaboration, but I fully agree with and IPA&M adopts Mr. Suazo's comments. By way of supplementation, my client was notified of the proposed rulemaking about a week before the filing, and we believe a true collaborative process should not be under the gun of an upcoming hearing date, and the commission should direct the parties to collaborate some more before there's a filing. We also oppose on public policy grounds, and thirdly, because the commission lacks statutory authority to enact many of these proposals. That said, I'd like to make some comments. Mr. Tremaine correctly states that I filed this morning based on receiving on the evening of April 12th the amendments to the proposed notice of hearing. I'd like to make some comments about those suggestions because as I indicated in the filing, I would make my comments here. Mr. Tremaine identifies correctly that there was House Bill 133 before the recent legislative session, which had the strong backing of the administration. It did not pass. While IPA&M believes that its failure to be enacted into law, combined with the administrative efforts to get that bill enacted into law, is highly instructive on the issue of the Commission's authority to enact the proposed rulemaking, I'd like to raise it for a more practical issue, which is the hearing date. As Mr. Tremaine alludes, and IPA&M hears, there's rumors that some version of House Bill 133 may be submitted in the upcoming legislative session. I'm going to briefly share a screen with you. This is the calendar of session dates on the legislative session, and on April 11th is the last day for the governor to, or I guess April 10 is her last day to act on legislation. April 11th is the date that unacted upon bills become pocket vetoed. So the proposed hearing date is prior to what we will know about the ultimate results of the upcoming 60-day legislative session. And the 20-day period there is constitutional under Article 4, Section 22 of the Constitution. So assuming the legislature's website is correct about the dates of the session, that is the date for the so-called pocket veto. Therefore, if the commission is going to move forward with the public hearing, which again IPA&M disagrees with, but if it does, the hearing should occur sometime after we all know what we're dealing with in terms of legislative history. I don't have a crystal ball, but it's very obvious or very easy to imagine a scenario where there's a reintroduction of some version of House Bill 133 in the next session, that some form of that bill passes with amendments, and given a bill that presents her with some but not all of what she asks for, or contains provisions that she may not have wanted, there's no guarantee we're going to know by April 7th what the governor has done with any bill that may alter the Oil and Gas Act. So we submit that some later date at the convenience of the parties would be more appropriate. We think that the notice of hearing, and I provide specific language in my filing, ought to contain a provision for concerning motions, because as IPA&M believes, and I think Namogas also suggests, there's arguments about the commission's authority to enact some or all of the proposed rulemaking. We take issue with the legal authority section and think it should be amended. In particular, it currently states the proposed rule is authorized, etc. We believe that it ought to state applicants contend that the proposed amendments are authorized, because this commission has not made any finding that it has the authority to enact these rules, and that issue will be disputed. I agree with Mr. Felderwert's comments about the testimony section. IPA&M is also considering expert testimony, and so we wanted to make clear that technical testimony includes expert witness testimony. And we believe that there should be a provision also that in the event, especially in the event of some developments in the 2025 legislative session, for good cause shown, written testimony can be revised, supplemented, or new testimony offered. Finally, Ms. Beasley, I think, articulates sensible and prudential reasons for submitting non-technical, non-expert testimony in writing, and IPA&M agrees with this proposal. For that reason, IPA&M contends there is no good reason for the oral comments section as written by the applicants, which they're proposing that anyone who essentially shows up at the hearing can offer testimony to the commission. Parties ought to be made to intervene and present their written non-technical testimony in advance. The commission should not get itself bogged down with surprise testimony, which none of us may anticipate. Additionally, I'd point out that both on the applicant side and at least two of the intervener sides, we've got membership-driven organizations. I don't think the commission ought to be inviting us all to engage in the game of having our members, their employees, their friends, whatever, show up with surprise testimony at the last minute. And therefore, IPA&M has suggested a completely different oral comments, which would be limited to traditional public comment that is usual for this commission and more appropriate for a public body. With that, thank you for considering IPA&M's comments, and we look forward to hopefully working with the parties on the rule before the commission considers any proposal. Thank you.
Thank you, sir. Appreciate it. Any other questions? Any, Dr. Ampoma, any questions?
Just a point of housekeeping, Mr. Chair.
Yes.
Are there any other
Sorry, yes.
persons appearing today that wish to offer comment on the proposed rulemaking? Okay, hearing none. Mr. Chair, members of the commission, if I may,
Please.
Briefly try to advise the commission on what we've heard here. Yes, certainly the commission, this is a proposed rulemaking, and Mr. Tremaine has accurately stated the concept that what is proposed today, what is put out for notice, does not necessarily need to be what is the final after a hearing. The test is a logical outgrowth. So if you decide that what is being what is in the petition is at least, as OCD has said, could be tweaked, it could still go out for notice as is. Now, the second point is if the commission does deem it prudent to initiate rulemaking, I do suggest that pursuant to the rules that we do have a hearing officer, and that would certainly make for a much more orderly procession of this proceeding. Now, as to the notice, there are a lot of things we can put in a proposed notice, such as those issues of who can appear in person, who needs to appear, who can appear virtually. That could be covered in the notice, as well as what testimony needs to be filed or not filed ahead of time. I am mindful of the Open Meetings Act, but more importantly, the public comment provisions of the State Rules Act. And as I'm sure all the attorneys here would acknowledge, it is a gray area, what is public comment versus what is even non-technical testimony. This came up in the PFAS as well. And so we do have to be careful. Limiting people to pre-filings when they just want to get up and say something might be a State Rules Act issue. But again, this could all be in what I'm hoping would be a consensus notice, or at least some consensus in a proposed notice that could be presented to the commission at its next meeting, especially if the hearing date, at least of April 7th, meets with some consensus by all the concerned parties. As to the concern about timing this with the legislature, certainly if there's legislative action that would obviate the need for any of this, that would be a wonderful problem to have. And this isn't legal advice, but waiting for a legislator to do something or not do something is a waiting for Godot proposition often. Waiting for a pocket veto. We do know that our Governor Grisham does have deep pockets in that respect, but again, that is still speculative. I did not hear from any of the parties here opposing the initiation of any specifics as directed to the specifics rather of the strike lines or add or proposed additions to the text. I suppose those will be tackled as part of the hearing if the commission sees fit. So, but the notice otherwise meets the requirements of both the State Rules Act and the commission rules. And again, I want to remind the commissioners, you may have questions about this, about the substance. I would strongly advise against getting too much into substance, as there could be some argument of prejudgment. I think there are folks who would want to show up for a hearing in April who would want to hear everything the commission has to say about this. So with that, I stand for any questions by the commission, and of course the commission can ask questions of those parties appearing today.
So I do have a question for Nemoga and then IPNM. So you are opposing the commission setting up a hearing for this, but so were you invited to the table or you were not invited at all?
Thank you for the question, Commissioner Ompoma. Well, I would need to confer with my client on the exact timing. I guess what I will say is that I do take exception with OCD and Mr. Tremaine's characterization that we're involved in the development of the language of these specific rules as proposed. And I am aware that HB 33 has been looming out there. It failed to pass. I am aware that these issues, that the issues that the rules concern are issues that the industry has been dealing with for years. But what I will say is that when it comes to the actual text that was submitted to the commission, that is not something that we feel that Nemoga was involved in as much as is practical and prudent, and in our mind, essential, so that the rules that are ultimately adopted ultimately make sense for the industry that actually has to abide by them. And I think that if you put rules in front of the commission that need significant modification, ultimately that leads to a poorer outcome rather than a positive outcome, because at the end of the day, we have to abide by the rules and the commission and the division have to enforce those rules. So the better they are, the more that we ensure that they make sense upon submission, that they make sense for the industry, the better product you're going to have. And that was not done here, which is why there are problems and reservations with these rules. You know, there's no magic with adopting these rules on the time frame proposed by the applicant. It is highly likely that a version of some of these rules will be adopted by statute after the legislative session next year. And so what the commission faces is the prospect, and what the industry faces is a prospect. And what the applicant faces as a prospect is, if there are statutes that are passed by the legislature next year, everybody's going to have to scramble to adjust their reasons and expectations and the nuance of those rules in the face of those adoptions, when in hindsight, we'll have been working on this very rulemaking that may in part have been addressed through the statutes. And so I think it is prudent for the commission to proceed carefully and slowly and work with and engage with industry so that we can do this effectively and well and not create additional issues for ourselves just for the sake of passing regulations. And I would remind this commission that many of these issues were addressed back in 2018. There's plenty of testimony on stripper wells and things of that nature and the impact economically. There's a robust record of the commission assessing these very issues. This is just another bite at the apple by the applicant, and they took that bite then. They took that bite at the last legislative session. They're going to take as many bites at the apple as they can in this upcoming legislative session. And for purposes of this rulemaking, we're going to have to deal with the fallout of whatever results, if anything, but it's possible that something will. And so if we have to scramble a month roughly ahead of our hearing to adjust to what the legislature has done, that kind of is a problem for everybody. And that's a waste of time, resources, effort, and energy, all of which are limited. So please keep that in mind. Thank you.
Mr. Commissioners, as the question was also directed at me, again, I will not repeat Mr. Suazo's comments. IPA&M was approached by the applicants on via email on June the 15th of this year about the proposed rulemaking, and I believe it was filed about a week later. There was no substantive interaction between IPA&M and the applicants. We were presented with rulemaking and told it was going to be filed, and we were graciously welcomed to provide them with comments, but it was not, we were not part of the process of developing the rules. Presented to us as a package and filed very shortly after it was presented to us.
Then I'll follow up to the applicant and then NMOCD. So are there any approach that the applicant and NMOCD taken to make sure that the key stakeholders, those are the companies that need to abide by these rules, more or less, allowed to participate, in the test for this rulemaking?
Thank you, Commissioner. So our intent in reaching out was not for that to be the sort of one and only opportunity to refine the rules, to work together, to discuss the proposals. We were hoping that would be the start of such a process, and I'm not aware of any requirements that we work to with any particular other party to craft the language prior to filing. But it was very much our intent that we would continue to do so and continue to refine these provisions and work together to try to find common ground, narrow the issues, all of that, between filing and hearing. And in particular, given that a hearing would be now in spring of 2025, if granted, that was fully our intent from the start, was that would just be the initiation of what we hope would be a more collaborative process and not sort of foreclosing anything further.
Okay.
Commissioners, Justice Chairman for OCD. So first a clarification, I may have misspoke or I may have just simply been misunderstood. I'm not sure which, but I was not intending to imply at any point that I had knowledge of NMOGA participating in the crafting of this particular language proposal. What I said, or what I intended to say, was that NMOGA was regularly involved in the stakeholder process, and that the proposal presented by WELC represents a proposal which is squarely within the content and the substance of those discussions from that stakeholder process that gave rise to the legislative proposals. So I am not aware of OCD having provided substantive comment on the current proposal in advance of its filing. But we were all part of that process starting in August or September of last year, I believe, running all the way through the spring. So that was my comment. And in terms of the stakeholder engagement, I would say that I do agree that this is simply the initiation of what OCD identifies as a very necessary and critical update to the reference rules. And we will endeavor early in the process to continue to engage in that stakeholder engagement. So I anticipate many meetings between all of the parties, exchange of additional red lines. OCD, in response to the petition, is already preparing to recommend revisions to the proposal, which will be shared with all parties. And we're pretty much, in my opinion, an open book as far as that goes. We did not participate in drafting the petition, so we haven't had those substantive meetings with the industry stakeholders yet. We will have them.
Mr. Chair, may I be heard briefly? Sorry.
Yes.
I did. Miguel Suazo.
Oh, I'm trying to look. I apologize. Yes.
No problem. Just to kind of harmonize what the applicant and OCD has said, and specifically I'd like to focus on the applicant. Their purpose after filing is now to encourage refinement and engagement and so on and so forth, modification of what they've proposed. And the problem with that, and let me just take one example. Applicant uses the term beneficial use in their application. Beneficial use is the rock upon which their application is built. And as an environmental and more importantly, a water law attorney, that creates problems. The term beneficial use is used in the Oil and Gas Act and the rules, but nowhere is it defined. And as we know from in the oil and gas context, terms of art are critical in any field of law. And protection of correlative rights, prevention of waste, those have a long body of case law behind them. Well, so does beneficial use. And beneficial use in the context of oil and gas is a very broad term. It's a very vague term. And it runs the risk of conflating two very clear and important sectors of energy and environmental law. And so if the applicant was truly concerned about ensuring engagement and refinement, at the very least, they could have brought industry to the table on the language of these rules so that we're not all faced with the next 6, 7, 8 months of trying to hash this out and make sure that the lines that are clearly drawn within the body of extant law are not conflated and convoluted and confused. So I can go on and on down the list, but I've been asked not to go into depth by Commission counsel. But again, these rules are half-baked at best and problematic at worst, not just now, but for the long term. And that is why NMOGA urges this commission to reject these rules, encourage applicant to come to the table with a serious proposal after we've had the benefit of seeing if the legislature is going to pass something that alters the contents of these rules by statute so that we can actually come back and have an actual productive rulemaking. So for those reasons, I encourage the commission to reject the rulemaking at the very least at this time. Thank you.
Listening to all the arguments, I still believe NMOGA still do have the opportunity to provide inputs to, let's say, this order, or let's say this rulemaking. So you still have the opportunity, other than just saying we should more or less deny entirely the application. You still have opportunity to make sure your members' concerns are more or less addressed in the final draft.
And we're not saying we don't have the opportunity. We're just saying the opportunity is now in front of us and not something that we're actually helping to put together constructively. And I think that does make a difference when you're facing procedural schedules, lining up witnesses, navigating what the legislature is doing. You know, everybody has commitments. And so I think it's problematic under the circumstances, was my point, not that we don't have the opportunity to participate in the process, Dr. Ampoma.
Okay.
Mr. Chair, members of the commission, and this isn't strictly legal advice again, but in my experience, lawyers respond well to deadlines. Lawyers respond well to hearing dates. And so to the extent we want to spur the parties to get together and work out what they can work out or realize what they can't, as Dr. Mpoma, you have said, there is ample opportunity between now and April to do that. And I have not heard anything. And it seems like there has been some reaching out prior to this petition. Again, so it is a long process. And as long as the final rule is a logical outgrowth of what is in the notice, the state law is satisfied.
So let me ask, what prevents us more or less setting the ruling date after the legislative session? More like, let's say, setting the date after.
Commissioner Mpoma, members of the commission, there is nothing that would preclude you from giving more notice, more time for this rulemaking to proceed. The law only gives constraints as to how little time. 30 days typically is so what you were proposing is certainly well within the commission's ability to do. If you feel like it is prudent for this hearing to be set several months after the end of the legislative session, that is certainly your prerogative, and that is certainly well within your discretion.
Will that be a problem for the applicant?
We would prefer an April hearing, but we are, of course, amenable to whatever the commission ultimately decides about the timing. Given that we have already sort of moved this forward to accommodate other things, we would, of course, prefer April and feel that that is still ample time for the refinement and collaboration that we've discussed. But of course, defer to whatever the commission decides.
There, and I'm just going to interrupt. I apologize. There was concern that, well, the governor has pocket veto authority for that particular week, which, okay, whatever. She has the authority to be able to do that, and that's her job. Could we postpone it by a week and start the 15th instead of the 7th? Would the parties be amicable to something like that?
Again, Mr. Chair, I think the parties would probably want to get together and propose a notice.
Sure.
And everything would be wrapped into what they would have in front of us for proposed notice, including the hearing date, the procedures for witnesses, for pre-filings. That could all be something that we could see at our next meeting.
Okay, so
in form of a notice.
Just to make sure I'm understanding, your advice is let's just say yay or nay whether we want to have the hearing, and then they can bring all that stuff to us.
Mr. Chair, yes, what I am saying is that you could vote today to initiate rulemaking, subject to the parties, subject to approval of a notice at the next meeting.
Okay.
I would have strongly suggested we get a notice out in some form by this commission after the next meeting, but we would give the interested parties opportunity to present that at the next meeting.
Okay. I just want to make sure that we also capture Commissioner Bloom. Were there any questions that you may have had, Commissioner?
Thank you, Mr. Chair. No, I too was interested in these questions around an appropriate date and could something that happens in the session realistically affect what might happen in this chamber. Ms. Beasley, I don't know if you want to, if you have any other thoughts on that, I'd be glad to hear them. We've heard from, I think, Nemogan, IPA&M on that. But if you have anything else you'd like to add.
Sure. I would say, given the sort of speculative nature of exactly what will even come up in session and even more so the speculative nature of what will actually get passed, even to the concerns about sort of having to scramble or be prepared, I would think it better to give ourselves deadlines, give ourselves these parameters, and to be preparing in advance in the instance that something isn't passed legislatively, so that we are not then scrambling to sort of come up with something and work out all of these procedural details. If something isn't passed that changes these drastically, while still leaving room for amendment should something get through. But in terms of that sort of causing a scramble to prepare should something pass, I think that one could argue that there would be a scramble if it didn't as well. And if anything, I think that this would allow the parties to prepare more thoroughly for whatever may happen and then adjust as needed if, say, the scope gets significantly narrowed by something that were to come through the legislature. It's unlikely that something would go through that would broaden the scope significantly.
Okay, thank you.
Any other question, Commissioner Bloom?
No, that's it. Thank you.
Okay. So, commissioners, I guess it's the question, do we want to proceed with a rulemaking?
Mr. Chair, I believe we should proceed with rulemaking, and I like Mr. Rubin's suggestion that we entertain specific dates, potentially at our next meeting, but sometime in the future.
Okay, thank you.
So as I understand it from Commissioner Bloom, the motion is to initiate rulemaking and to approve a proposed notice at the next meeting that would encompass the concerns.
Okay, so that was the motion. Do we have a second?
Mr. Chair, did you make the motion?
Oh, I'm sorry. I thought you were making the motion.
Oh, I can't make it.
That's why I was wondering. I was like, oh,
No,
okay.
I state the motion and then I hope that one of my clients says so moved.
Okay. So moved.
Yeah, so moved.
I'll second.
And can we have a roll call vote, please?
Okay. Commissioner Bloom,
Approve.
Dr. Mpoma,
Approved.
and I approve as well.
Okay. Anything further from the parties?
Thank you. And we look forward to following up about the notice.
Thank you.
Nothing
All right.
further. Thank you.
Mr. Chair, do you want a brief break or shall we move right to item 3, which is, I believe, a hearing?
I was thinking maybe we take a 10-minute and we can go from there. So
Okay.
Thank you.
thank you, everybody.
Thank you.
Such a short meeting.
Oh, right. It was like that 3 seconds. Yeah. Forgot about that one.
Our next case is case number 24594, application of Targa Midstream Services LLC for authorization to inject in Lee County, New Mexico. Are all the parties present?
Yes, I believe so.
Yes.
Excellent. Great. So, Ms. Hardy, we will start with you.
Just make sure you turn.
Okay.
Thank you. Dana Hardy with Hinkle Shaner on behalf of Targa Midstream Services LLC.
Hi, my name is Anna Sinnigan, and I'm representing the Oil Conservation Division today, along with Jesse Tremaine, the OCD Legal Director, who's here to help me if I need it.
Excellent, Ms. Hennigan. Thank you. You'll do good.
And Commissioners, would you like me to provide a brief opening?
Please go ahead,
Oh.
Ms. Hardy.
Well, thank you all for your time. In this case, Targa seeks authorization to inject treated acid gas, which we will refer to periodically as TAG, from its Copperhead gas processing plant into the proposed Copperhead AGI number 1 well. That well will be located in Section 13, Township 24 South, Range 32 East in Lee County. The well is in an underground injection control Class 2 well. The well will be a vertical well, and we've provided the footages of the location in our exhibits. It will inject TAG into the Devonian 31, Upper Silurian Riston, and Lower Silurian Fusselman formations at a depth of approximately 17,299 feet to 18,689 feet. The well's proposed maximum daily injection rate is 26 million standard cubic feet per day, and the proposed maximum surface injection pressure will be approximately 3,460 pounds per square inch. As we will show in our testimony in our exhibits, the well as proposed in the C-108 will not cause waste, impair correlative rights, or harm public health or the environment, including through the risk of induced seismicity. And in addition, the well will facilitate the sequestration of TAG and CO2, which is in the public interest. And I will add that OCD has proposed permit conditions here, and as Mr. Eels will explain, Targa has agreed to those proposed permit conditions. So Targa's application for the well is reasonable, comports with the requirements of the Oil and Gas Act, and we would ask that it be approved.
Thank you. Ms. Sennigan,
Yes, may we make an opening statement?
please.
Good morning, Mr. Chair and Commissioners. My name is Anna Sinnigan, as I previously introduced myself, and I'm here with Jesse Tremaine, the OCD Legal Director, and he's going to help me as necessary. I would like to briefly summarize the OCD's case today. The division will present one witness, Mr. Millian Gebremichael. In addition, the division will present 2 exhibits. One will be the conditions of approval and the other will be the resume of Mr. Gebremichael. The division supports the approval of the well, subject to the inclusion of the permit conditions identified in Exhibit 1 and the incorporation by reference the contents of the C-108 form application submitted by Targa for this case. The division's purpose is to conserve oil and gas, prevent waste, protect correlative rights, protect public health and the environment, and protect sources of drinking water. Thank you.
Excellent. Thank you, Ms. Sennigan. So, Ms. Hardy.
Thank you. Targa's first witness is Mr. Matthew Eels.
And we need to swear him in, correct?
Sure. I will swear the witness. Mr. Eels, you good? You've raised your right hand. Do you swear that the testimony you will give today will be the truth, the whole truth, and nothing but the truth under penalty of perjury? You are duly sworn. Proceed, Ms. Hardy.
Thank you. Can you please state your full name for the record? Can you turn on your microphone?
There we go. Robert Matthew Eels,
Mr. Eels, by whom are you employed and in what capacity?
Target Resources, as the Vice President of Regulatory Affairs.
What are your responsibilities in that position?
I'm responsible for the permitting of and compliance with AGIs.
Have you previously testified at a commission hearing?
Yes,
Can you please briefly summarize your education and professional experience?
Yes, I have a master's degree in environmental engineering from University of Kansas, 26 years of oil and gas experience in international and domestic roles, primarily in environmental health and safety. And most recently, 5 years working in the state of New Mexico and our operations and midstream operations.
Based on Mr. Eel's qualifications, I would request that he be qualified as an expert in environmental engineering.
If there's any concerns? None? Okay,
No objection.
excellent. Thank you.
Thank you. I would like to share our hearing exhibits so we can go through them. So let me share my screen. Mr. Eels, can you see the screen that's in front of you? Is that turned on?
No, just showing the same images.
Okay.
Yeah,
Can you see the exhibits now?
yes.
Okay. Mr. Eels, can you please, let me just get to it, identify the document that is marked as Targa Exhibit A?
Yep, that is our C-108 application and the hearing exhibits.
And are these documents true and correct copies?
Yes,
And let me just go to the C-108. Did Targa retain New Mexico Institute of Mining and Technology, which I'll refer to as New Mexico Tech, to prepare its C-108 application?
yes, we did.
And were you involved in that preparation?
Yes,
And will other witnesses testify here today regarding the content of the C-108?
yes.
Commissioners, just so I don't forget later, I'd like to move the admission of Targa Exhibit A, which is the hearing application, and the attached C-108.
Any objections?
No objection.
Submitted.
Thank you. Let's next go to Targa's hearing presentation, which hopefully this isn't making people dizzy. I'm almost there. Okay. Can you see that, Mr. Eels?
Yes, I can.
Okay. And can you please identify this document?
Yes, that is our hearing presentation for today.
And were these slides prepared by you or under your supervision?
Yes, they were.
Okay. And here on slide 2, this is outlining Targa's presentation and witnesses today, correct?
That is correct.
Okay. So you will provide the overall introduction, and then Mr. Alcacey will provide the site geology and hydrogeology and the dynamic reservoir simulations, and Mr. Ragsdale will provide the wellbore design.
Correct.
Thank you. Let's first look at the overview of the Copperhead area and slide number 4. Just shrink this down a little bit. Can you please summarize or describe the information provided on that slide?
Yes, this slide is demonstrating the growth that we have seen to date and anticipated growth for gas and oil volumes. To the right being the gas, you'll see that we've seen a 17% cumulative annual growth rate and expect that to continue growing at least at 6% from here. So basically, it's just showing what most know, and that the oil and gas production is growing in southeast New Mexico.
And does this slide support Targa's need for this well?
Yes.
Look at the next slide, slide 5. Can you describe generally the well location?
Yep. So the proposed well, we're calling Copperhead AGI, is located about 25 miles west of Jal, New Mexico, again in the southeast New Mexico corner.
And is additional natural gas treatment capacity necessary in this area?
Yes, it is.
Can you describe the information shown on slide 6, which involves the Copperhead area gathering and processing needs?
Yes, so the image on the left shows the gathering systems that exist for Targa. You'll see Roadrunner, Carlsbad, Red Hills plant, and then Copperhead about 5 miles west of Red Hills, down into plants in Texas, Bull Moose and Wildcat. So it's just showing this particular area and the growth we anticipate. You'll see the gathering lines are not as prevalent around Copperhead, but will be growing. And then to the right is our expectation for growth and takeaway need for TAG, specifically related to this well that we're requesting. We're expecting to see 10 million cubic foot per day within the first year of plant operations and stabilizing with potential growth at the upside with the brown dotted line.
And does Targa require additional injection capacity to meet these?
Yes, it does.
With respect to the environmental benefits of TAG injection, can you please summarize those?
Yeah, so the advent of TAG injection came from protecting the environment, where historically sour gas, it's a mix of H2S and CO2, was flared at sites, which creates a large amount of sulfur dioxide. And it's something that, of course, one of the critical air pollutants with EPA. So there was a conversion to injection of this TAG 15, 20 years ago, and maybe a little bit beyond that in other countries, where you're taking that from the atmosphere and injecting it into the formations to eliminate that flaring and creation of SO2.
And without an AGI well, how would oil and gas operators treat their sour gas in the field?
Yeah, it would be flaring.
Does the injection of TAG eliminate flaring or eliminate or reduce flaring at the plant as a control for sulfur derived from the processing of sour gas?
Yes, it does.
And does injection into an AGI well reduce the need to vent CO2?
Yes, it does.
Will the injection of TAG here minimize CO2 emissions from the plant?
Yes, it will.
In your opinion, will there be environmental benefits if Targa is authorized to inject TAG into the Copperhead AGI #1 well?
Yes, certainly.
Will Targa complete an H2S contingency plan before commencing injection?
Yes, we will.
And in your opinion, will Targa's H2S contingency plan comply with all of the requirements set out in Part 11 of 19.15 NMAC?
Yes, it will.
Mr. Eels, have you reviewed OCD's proposed permit conditions?
Yes, I have.
And I'm going to pull those up. And I believe they are Exhibit 1, and they are attached to OCD's pre-hearing statement. You've reviewed those plant
Yes,
conditions?
I have. Yes.
Okay. And does Targa accept those conditions?
Yes, Targa accepts those conditions.
Okay, thank you. Go back momentarily to trying to get my screen to go back to my exhibits, but it's there. There we go. Okay, so Mr. Eels, let's go next to our notice information that we have provided in this case. Can you please identify Targa Exhibit C?
Yes, these are the notices that we provided for the regulation.
And those include our hearing notice letter, the certified mail and the certified mail receipts, and a chart listing the parties.
That's correct.
And was notice of this hearing provided to all affected parties?
Yes, it was.
In conclusion, Mr. Eels, in your opinion, will the ability to inject treated acid gas into the well result in more efficient operation of the plant?
Yes.
And in your opinion, will Targa's proposed method of disposing of TAG protect public health and the environment?
Yes, it will.
And will it prevent waste and protect correlative rights?
Yes.
Thank you. Commissioners, I would move the admission of Targa Exhibits B and C because I don't believe I did that previously.
Any objections?
No objection.
So they're so submitted.
Thank you. I have no further questions for Mr. Eels. He's available for cross-examination or questions from the commission.
the training opportunity, so we'll just give them a second.
One moment.
No
please.
problem, Ms. Sennigan.
Sorry about that. Okay. So I would like to, you mentioned OCD Exhibit 1. I would like to direct your attention to that. On number 18, it requires a redundant well. We were wondering about your operational plan and intent of the redundant well.
Yeah, we do intend to meet the requirements of number 18 to permit a redundant well. That would now allow us, if there was a need for the redundant well, to drill quickly.
As you sit here today, do you have an intended depth for that well?
No, the very early thought right now would be a DMG well, to be able to be in the similar property, stay within our property boundaries, because we do have state land to the north, and it's best just to stay there. So if that were to be drilled, we would have this Siluro Devonian and then a stacked DMG.
No further questions. Thank you.
Thank you, Ms. Sennigan.
If I may, any redirect, Ms. Hardy?
No, thank you.
Okay.
Dr. Poma.
Thank you. Mr. Yield, so I'm just following up with the redundant well. You said it's going to be in the DMG and then the Devonian. So can you really clarify?
Yeah.
Or are you still in the preparation mode?
Yeah, I probably didn't state it clearly. This AGI number 1 that we're applying for is for the Siluro Devonian. The redundant well that we intend to permit as part of number 18, at this point, it's looking like a DMG for that well would be the intent.
Yeah, because I was wondering if you are going to go back to the Devonian, then my question is, how far would your redundant well be away from, let's say, the injection well? But
it's a good question. It's a little early at this stage, but we're looking at this well is on the east side of the property, number 1. The second would be on the west side of the property. That's about 1,600 foot to the west of this existing well, or this well that we're here for.
okay. So can you tell the commission the current gas production, more like the TAC, coming from the Copperhead facility right now?
Right now, it's all of an envisioned facility. It's a facility that is currently a large compressor station that will be growing into a larger plant. So we do expect to see on the slide that I covered, I think the tag is 12 million. Let me look at that real quick.
Page 6.
And that's within the first 3 years with potential of 25 million, but 12 million for what we foresee in the future for the first 3 years.
Okay.
This well is intended to be permitted and drilled proactively to be well in advance of bringing the gas to the plant that's also would be built at the same time, or enlarged was the proper word.
So if your initial estimate is about 12,000 MCF per day for a period of about 3 years, then why is Targa requesting 26,000 MCF per
And
day?
it would be to anticipate the growth that we expect to see in that area.
Thank you.
Yes.
Commissioner Bloom, did you have any questions?
No questions. Thank you.
Mr. Chair, I asked if this, unless there's anything further from the division on those
No,
questions.
thank you.
I ask that this witness be excused.
So excused. Thank you, Mr. Rios.
Thank you. Targa's next witness is George El-Kassi.
Mr. El-Kassim, could you raise your right hand, please? Do you swear that the testimony you will give today is the truth, the whole truth, and nothing but the truth under penalty of perjury? You are duly sworn. Proceed, Ms. Hardy.
Thank you. Can you please state your full name for the record?
My name is George El-Kassi.
And is your microphone turned on?
Yeah, it's better.
That's better. There's feedback.
Ms. Hardy, there's some feedback as well. Can we just have the members on Teams please to mute themselves? Thank you. Go ahead, Ms. Hardy.
Can you state your full name again, please?
My full name is Khader George El-Kassi.
And by whom are you employed and in what capacity?
I'm employed by New Mexico Tech Petroleum Recovery Research Center.
What are your responsibilities in your position?
I'm a research engineer as well. I'm a section head for the industry service. I lead the technical team that support the industry in their challenges and anything that they require.
Have you previously testified at a commission hearing?
No,
Can you please briefly summarize your educational and professional background?
I have a bachelor's degree in electrical engineering. I spent 20 years in the industry with Schlumberger. I started working offshore in the Gulf of Mexico, Caribbean, and South America, where I was a team lead on data processing, seismic data processing, and quality control. Like I said, I spent 20 years Schlumberger. My last position was with Schlumberger Carbon Services as a global monitor and seismic manager for Schlumberger Carbon Services. I left in 2017 and I joined in New Mexico Tech's Petroleum Recovery Research Center in November of 2017, and I've been there since then.
Thank you. Based on Mr. El-Kassi's education and experience, I move that he be qualified as an expert in geophysics and subsurface project management.
No objection.
Is so entered.
Thank you. Mr. El-Kassi, let's look at your slides. And so we'll start with the site geology review. Can you please explain what is shown on slide 8?
Yes.
And can you speak a little bit slowly for the court reporter?
Sure.
Thank you.
So typically when we build a geological model, we always examine the wells, offset wells around us. And this slide shows the well within 2-mile radius. And the small circle is a 1/2-mile radius. The table in the top table shows the 2 wells that are within the 1/2-mile radius. One of them is actually SWD well that was permitted but not drilled. And according to our research, the permit has expired. The second well was drilled in 1957 for production. However, it was plugged the same year. And you can see within the 1-mile radius, you have several also oil and gas wells. And in the 2 miles radius, there is some more wells there. We just take that into account when we build our model.
So is it correct that no wells produced from the proposed injection zone anywhere within the 2-mile radius?
That is correct.
Look at your next slide. Can you explain what's shown here on slide 9?
Yes, this is actually the copperhead is in the Delaware Basin, which is in the Greater Permian Basin. The units were divided with the Tobosa Basin. The geological model is based, of course, we used the available well logs from the area, as well as we licensed some 3D seismic that covered that area, and that's how we build the model based on that geology and based on the well logs and the seismic data.
Can you please explain what's shown on slide 10,
again-
paleogeography and depositional environments?
Yeah, so again, this is this basically what we were looking at. It's described as the Copperhead area is described as a shallow water, high energy carbonate platform.
And what is shown on the slide 11?
Okay, this is consists of the what we can see this defines basically the confining zone as well as the injection zone. Our injection zone consists of the Solar Devonian, which is Solar Devonian is the 31 as well as the Reston. And also it includes the Fossilman, which is about 1,380 feet in thickness. And we have the confining zone, which is our primary cap rock or seal is the Woodford Shale, which is approximately 480 feet. I'm sorry, 140 to 180 feet. Then also we have our secondary cap rock or seal, which is the Barnett Shale as well as the Mississippian limestone. The total cap rock we have or the seal is about 780 feet.
And based on your analysis, is this an appropriate injection zone for the AGI?
Yes, because of because of the porosity and permeability, the cap rock has very negligible porosity and permeability, which constitute a good cap rock.
And can you explain what slide 12 shows, please?
Okay, so we obtained wells from the area, of course, and this shows how the thickness of the injection zone, which is about 1,380 feet, that include the 31 and the Reston, as well as the Fossilman. And the confining zone, like I said, is 780 feet. You see on the graph, you see the AGI 1 well. To the left of it is the gamma ray curve. To the right of it is the porosity curves that from 5 wells, and this is what we use to derive our porosities.
And what is shown on slide 13 regarding the petrophysical properties?
Okay, so again, this is the closest well we can find with D blocks that we can use was about 4.4 miles. The Cyclone Federal. So the majority of the porosity, as you see, it's highlighted in yellow. It could be pressured here. Basically, that's where the secondary porosity comes from. Maximum porosity in the injection zone is 10%. The Woodford Mississippians are the confining zone, and they have negligible porosity.
And what is shown on slide 14, please?
This actually represents the boundaries for the seismic data we've licensed to help us build our model.
And can you explain the seismic interpretation shown on slide 15?
Okay, yes. So this interpretation, we interpreted different horizons. This represents the tops of that, the Fossilman, of course, and you see the Solar Devonian were there, as well as the Barnett Shale, which is part of the cap rock. And this was interpreted, of course, using the well logs and the 3D seismic that we licensed from that area. And again, the thickness of our injection zone is approximately 1,380 feet, and our cap rock is about 780 feet with low porosities and permeability.
And let's look at slide 16. Can you explain what that slide shows regarding faults?
Okay, so what when we build a model and we look at the well location and we explore around the well, of course, to identify any faults within their area. Based on our interpretation from the seismic, we identified two faults with minor displacement. They pass through our basically in the area where we are looking at, and I don't think there's a well to the northeast. It's about 0.88 miles from our well. The one to the southwest is about 1.55 miles to to the southwest of us.
Do these faults create any concerns regarding the proposed injection into the Copperhead AGI?
Based on our analysis, no, and as you can see in the coming slides, we have done some analysis, but based on our analysis, no.
What is shown on slide 17, please?
Again, this is we interpreted, of course, on the tops here, we split them so we can have a better view, and we overlaid the two faults. If you see the one on the north, basically north to northeast, and the one in southwest, we want to see how they are represented on the tops of our of the confining zone. This is basically the confining zone. As you see on the bottom right-hand side is the Woodford Shale. And then you have the Mississippian limestone and the Barnett Shale. Again, they combine to be about 780 feet in thickness.
And will these confining layers act as a geologic seal that prevents the migration of tag outside of the injection interval?
Yes, based on the values of the porosity and the permeability, yes, they do, what constitutes a good seal and good caprock.
And what is shown on slide 18? Please.
Again, this is the interpretation of our injection zone, and you can see the Saludo-Devonian, and you can see also the Fossilman formation. Basically, this is the top. We just want to show them separately.
And what is shown on slide 19?
Okay, so one of the things we consider also is what we call microseismicities or induced seismicity in the area. This slide shows what we like to call stations. They're seismometers or geophones that were installed and maintained by New Mexico Tech Seismology Observatory, and this is within 10 and 20 miles, I believe. Yes, the stations, and these stations are monitored in real time, and the data is freely available. Historical data and actual real-time data is available.
And looking at slide 20, can you describe the seismicity within 20 miles of the Copperhead AGI site?
Yes, so we looked at some historical data here to see if any induced seismicity, happened within the past few years, and what we found out, the closest event was about magnitude of 2. Closest to the AGI well was magnitude of 2. It's about a little bit over 8 miles away from us. But if you can see that most of the events are clustered in the southwest part of the graph, and that's about 20 miles away from where our well is. And they're three magnitude of 3 and below.
Do these findings create any concern regarding injection into the proposed well?
No, not based on our analysis.
Were these slides that we've just discussed prepared by you or under your direct supervision?
Yes.
And are they true and accurate?
Yes.
Let's look next at your reservoir dynamics simulation. And looking at slide 22, is this a summary really of what of the requirements that apply to TARG as well and how it will meet them?
Yes, going back to what the counselor has mentioned earlier, this is, of course, we do in the study and make sure that we comply with the New Mexico rules, and we to prevent waste, of course, and we'll protect correlative rights. And also we prevent any harm to the environment, and we protect the source of drinking water here. Now, specifically what we wanted to prove here is the Saludo-Devonian, our injection zone can take the 26,000, the 26 figure that we are asking for or requesting, and keeps it in the ground safely. And also we want to make sure that we are operating at or below the maximum surface injection pressure that's approved by the commission. And the injection aim, of course, we want to get rid of the waste to protect the environment.
And were you involved in preparing the reservoir dynamics simulation for this well?
Yes.
Can you please describe the model?
Okay. So when we do the simulation aims to identify the behavior of the tag plume, if you'd like, and for us to build the model, we take into account, of course, the composition of our tag. In this case, we have 70% of CO2 and 30% of H2S in this case. And also we simulated for 60 years, starting 2025 to 2085, and that includes 30 years of injection and 30 years post of injection. Okay, again, we want to make sure that we are performing that 26 mm SCFD is we're staying within the maximum injection pressure at the wellhead, and the injection zone again here is about 1,380 feet. This is and you can see the confining zone overlay, the Woodford and the Barnett at about 780.
And looking at slide 24, what are the petrophysical parameters of the model?
Okay, so these are derived, the porosity and permeability are derived either from the literature or the literature and core reports. In this case, we wanted to show that the maximum permeability here for our injection zone is 10%, of course, and we want to show that we show in here that the low permeability and porosity for our confining zone, which constitute a good cap rock. And as you see on the right-hand side, the column right-hand side, where it identify which formation is seed and which formation is our injection zone and the corresponding permeability and porosity.
Mr. Alkassi, can you please explain what's shown on slide 25?
Yes. So that's when we do the simulation, we build a certain model, and this is basically the model dimensions. So our model dimensions here is the model is close to 10 square miles, and the number of cells as you see on this is all over 1 million cells, and the cell size is 100 feet by 100 feet.
Okay, and then looking at slide 26, model initialization, can you please describe what's shown there?
Okay, so there is when you do the simulation, you take into consideration two things. One of the things you take, of course, is the bottom hole pressure, and that's the wellhead pressure, and also you take the temperature. And the temperature here, we obtain the temperature, of course, from the literature. Also, we assume in our simulation, we assume in the reservoir that we have completely 100% brine. That's why you see the value of number 1, which is saturated water. Then we have the saturated water, which is we call SWI, what they refer to as irreducible. This basically means that we have 45% of that space to inject the tag.
And what is shown regarding the model initialization on slide 27?
This is also another parameter that we consider in our simulation, and which is the salinity in the area. So what we did is we looked around. We took 11 miles radius around us, and we identified 3 different wells, and we took the salinity from each well, and we averaged it out. That was an input to the model, one of the inputs to the model.
And then what were the simulated injection parameters as shown on slide 28?
Yeah, so the simulation injection parameter, this represent actually the calculation for the maximum wellhead pressure. And it was calculated based on 0.2 gradient. And also the calculation for the maximum bottom hole pressure, and which is calculated based on 0.65 gradient. We need to keep the bottom hole pressure at 90% of the formation fracture pressure.
And what's shown on slide 29?
This is actually the results of of our simulation. So these graphs represents, the green graph represent the wellhead pressure, and we wanted to make sure we're at or below it. And this graph shows that based on our simulation, it stayed within that. Same thing as the bottom hole pressure, it stayed within the maximum allowable. And also you can see that the pressure stayed steady through the injection period till we reach the 2055.
Mr. Agassi, if you could probably slow down a little bit more, I'm sure it would help our court reporter. I know it's difficult. Could you please describe what's shown on slide 30 regarding the tag plume?
Okay, so this is the tag that you can see AGI well in the middle of the circle. This circle represent the development and the movement of the tag plume on 5 years increment, and you can see it from 2030 to 2060. And also, this is the largest extent of the tag plume that we find here is just a little bit over 1 mile, with injection rate of the 26 that we are applying for.
And then what does slide 31 show regarding the plume?
This is again showing the plume, but also here we are displaying the vertical extent of the plume within the formation, within injection formations.
And let's turn to fault slip potential. Can you explain what's shown on slide 32?
Yeah, so since we identified the 2 faults, so we decided to go ahead and try to study the effect of our injection on that. But here was showing the distances for these faults from our injection well.
And what is shown on slide 33 regarding the plume?
This is the plume, the tag plume in relation to the faults. You can see the one in the northeast and the one in the southwest. And this is a 5-year increment, of course.
So the plume doesn't reach the faults?
The plume does not. According to our analysis, no, it does not reach the fault.
And then what does slide 34 show about the CO2 plume?
This is similar to the slides before, except a little bit more colorful, of course. This came out with an output from our simulation software. But it's very much it identifies where the faults are in relation to the plume, to the tag plume.
And then what are the fault slip potential inputs?
Okay, so fault slip potential software developed by Stanford actually, and it's used in the industry. This table actually displays the parameters that were input in the software to calculate the fault slip potential in that area. The software takes into account the azimuth and the dip of the faults, as well as the regional stress.
And as shown on slide 36, what is the pressure change needed to activate the fault?
Okay, so from the fault slip potential software, the output you get is what is the pressure required to activate a certain fault. And this picture is showing actually where the faults are, and is displaying also the tag plume development and the pressure front from that plume development.
And does this show that there's no fault slip potential risk after a 30-year injection period?
That is correct. The next slide will show actually the values that we calculated.
Okay, and then can you describe what's shown here on slide 37?
Yes. So there are four different values. The faults that you see in the northwest, in the northeast, and the southwest. These are the faults we took into consideration when we ran our program. I start with the northeast one. The northeast fault, as you see, 1787 psi is what represents the pressure that came out, or the output from our fault slip potential software. And the 250 psi is what came out of our simulation software, which when we examined the development of the plume. And as you can see, it's much less than what it needs to activate that fault. And similarly, on the southwest, as you can see, the 2849 came out of the software from the fault slippage software. It's at 2849 compared to 150 PSI that came out of the output from our simulation software. And you can see it's much less than what's required to activate that specific fault.
So is it correct that injection into this AGI as proposed will not be sufficient to activate the faults?
Yes, that's accurate.
Okay, and Mr. Alcasi, based on your geophysical evaluation, is it your opinion that the Devonian, Upper Silurian Riston, and Lower Silurian Fusselman formations are appropriate to accept the injection of TAG at the location of the Copperhead AGI?
Yes.
Is it your opinion that TAG will safely be contained within the injection interval?
Yes.
In your opinion, will the injection of TAG into the Copperhead AGI result in any increased risk of induced seismicity?
No.
Based on your analysis, will injection into the well prevent waste, protect correlative rights, and protect public health and the environment?
Yes.
Thank you. I have no further questions for Mr. Kasi.
The division has a few questions. Mr. El-Kasi, we'd like to clarify the units that you've used. You have reference to thousands regarding the injection rate, but the exhibits are labeled as millions. Can you please clarify for the commission how you are referring to the units in the presentation?
26 million standard cubic feet per day.
Okay, thank you. I have a few more questions to ask. For your reservoir simulation calculation, you estimated the bottom hole temperature to be 225 degrees Fahrenheit, which is close to 230 degrees Fahrenheit that could cause strength retrogression. Do you think the well will reach to that bottom hole temperature in a dynamic state?
I don't believe so. That temperature actually, the 225 was derived from literature. It's regional in that area, and that's what we use for our modeling.
I apologize. Can you please explain for the commission what strength retrogression is?
I have to get you that answer during a break. I don't have that answer right now, but I will get it for you during break.
One moment, please. So is it your testimony that the temperature will not exceed 225 degrees Fahrenheit?
Yes.
Okay, I have a few more questions. What convinced you to apply a 0.3 Poisson ration, excuse me?
That's actually, this question is better suited to be answered by Mr. Paul Ragsdale. This is something that has to do with the drilling.
Okay, that's fine. Thank you. Okay, I have one more question. Have you compared the fracture gradient acquired using Eaton's formula with the fracture gradient acquired via step rate tests for other AGI wells?
I'm sorry, you were talking about the fracture or the fault slippage?
The fracture gradient?
The fracture gradient, no, the fracture gradient is we use that we use 0.65 psi per foot, which is pretty much standard.
Okay, thank you. No further questions.
Any redirect by Ms. Hardy?
I do not have redirect. I don't think you're done yet, though.
That's what. Any questions by the commissioners? We'll start with Dr. M. Coleman.
Sorry. Go ahead.
Okay. Yeah, thank you. I do have couple. So let's start with slide number 8. If we can go to slide number 8.
I think I'm there.
So, okay, slide number 8 is up. So I do see the star, which is the proposed AGI well. Now, you've shown that there are 2 wells that are very close. One was drilled in the 50s, but was quickly abandoned. And then the other one was not even drilled at all. But within, let's say, couple of miles radius, are there any production wells in the shallower sections that are located in here?
Are you asking production wells within the 2 mile radius?
Yeah.
Okay. Let's see. Okay, I have some notes here. Was it? It was plugged. Within 1 mile, there are 8 active wells, gas and wells, and 1 SWD well within the 1 mile. Then within 2 miles radius, there are 2 active SWD wells and 1 plugged.
I do see. So there are essentially multiple wells, though. So you do have 2 circles. So the first circle is what will the first circle be?
Half a mile, and 2.
Okay. So if I look at your legend, there are a lot of active oil wells in there. Now, my question, and even there is 1 active gas well I see within the 0.5 mile radius. So I think probably this question will be more suited for Mr. Raxter with regards to how that well location was selected. Because if you are very close to, let's say, a production well, you're going to have a lot of problems when you are drilling, especially if they've taken significant amount of gas from this well. So that is a question pending, though. So you don't necessarily have to answer that, but I want to know what analysis was done to choose that well location to avoid any potential issues when we're drilling this particular well, because you might end up not being able to drill that well. You have gases coming up at you. So I want to know how that well location was selected, and then if there are any mitigation plans available to deal with this particular problem, if just in case it comes up. So you don't necessarily have to answer that. Now let me ask, how many wells had porosity and permeability that went into the modeling?
The deepest well we have for porosity and permeability was the one I mentioned, the SWD well, that about 4.4 miles from us.
So that will essentially be only 1 well available to do the entire petrophysics?
That's the only deep well that goes into our formation, yes. But there are other wells that we use, but they're not as deep.
Well, I want to stress on that. So let's go to slide number 24. So from that deep well, then you got all these porosity and permeability data that went into the modeling.
Of course, we the porosity, we use that well as one of our data points. Yes. However, we also use the literature, and we have some core reports that we for that.
So then my question back again, how many wells had porosity and permeability that went into the modeling?
5 and we have 1 gamma. So there is 5. If you go back to the slide where they show the graphs.
The one we were looking at, let's see, this one? Or
No, it shows the well logs down.
That'll be slide number 12.
12. Yeah.
Yeah, this one. So as you see on the left-hand side, we have the gamma ray, and on the right-hand side, we have data from 5 wells that we use.
But what are those? Like on your right-hand side, what are those? Are they still not gamma ray logs? Because you are doing well correlation. So you're just telling us how the structure was being developed, but not porosity or permeability, except some of these well logs that I'm seeing is a porosity log.
Right. So, like I mentioned, we have from the literature mainly that we derive the porosity and the permeability. The permeability actually was also derived using the core reports that we have from there, and the deep well is what we use mainly. Yes.
Well, I don't. So my question is still not answered though. Like, so we go to slide number 13. Slide number 12 is not porosity logs, anything. It's just a gamma ray log trying to show the surfaces. So definitely on this particular slide, number 13, you are showing where you got the porosity from. So my question is, was this based on this single well that the petrophysics was derived from? The reason why I'm asking that is I want to know, is your model that you are using to more or less suggest to the commission that you want 26 million, is it a heterogeneous model or is it a homogeneous model?
Okay. Yeah. So we have some lateral variation within that, and also we looked at the seismic from that area, and now I understand what you're asking. I apologize, I didn't understand. Yes, the model is definitely has some variation laterally and variation horizontally, but is not because of the data that we have, the available data we have. We had to make some assumptions, and so it's not, I wouldn't say it's 100% heterogeneous, but also it's not 100% homogeneous. We had to make some assumptions to come to a point in between that will give us the answer we are looking for.
On slide number 25, let me see if we can get to the bottom of this. So slide number 25, would you say that this one is an inversion derived porosity?
Did we? To be honest, I cannot recall, but I believe we had done some inversion in this area. Yes.
Well, let's go back to slide number 12. I think that needs to be clarified though, in terms of how many let's say how many